But I have one matter in 25, item number 10. So what I would requesting your lordship that let me complete that so that I can fully devote here. Otherwise, my mind will be there. That is also for hearing. My brother, I think he will accommodate definitely.
You would also accommodate everybody because it is a Saturday.
Yes, yes, lordship.
Nice enough.
Hey, what to do today is Saturday and
No
that
issues. You
matter-
finish item number, court number 10, come back. You finish it there and come back.
Much obliged.
Obliged, Lord.
May I please, your Lordship?
Yes.
Lordship, I beg to mention for listing of a IA in a criminal petition for order correction. Earlier mentioned, but unfortunately this order correction IA was listed before Justice P. Sokia Court. And I prayed that matter may be listed before appropriate bench. Appropriate bench is this bench. So, my lord, Wednesday this may come.
May I please, your Lordship. Lordship, with the consent of other side, I beg to mention item number 2. Lordship, in this matter, both the Angus counsel is out of stage.
It's an old contempt. Why is it still pending? 2018. It was directed to be listed on 16th.
Lordship,
But what happened here? Claiming the appointment of the Malad APS, some public service, referential and
Yes. Did he make an application? Did he make an application for a in a recruitment drive is the issue.
selected Malad because I am for the immediately that
We will list it on we will list it on the 16th. If his case has not been considered,
disseminate the last.
he has to forward it.
That was forwarded because now he has also reply from the various departments like because in Assam, all the departments, he has received the letters, he has filed additional affidavit, in the
Since they are asking for time today, we'll have it listed on 16. We'll have it on 16. Point it out to us. I think with the consent of respondents, they have made a mention. An adjournment slip has been moved in this matter. Let's place this matter again on the 16th of February, 2026.
obliged.
17. Yes. File to side over 16. Last order to likha ase this. 17. 17th of February. He can get fixed. As he can get fixed out, he go. 7th. It was 7th February. You heard 17th. We'll keep it on 16th.
16.
My pleasure, Lordship. Lordship, I beg to mention for listing of an IA, Lordship. I have for Lordship impediment of party, Lordship. I have filed an writ petition,
Issue is there is a senior bench.
but today is not sitting.
Today not sitting. Why don't you make a mention on Monday? Get it listed on Tuesday or Wednesday. It is for what?
I have for implement of party, Lordship. I have filed an writ petition, Lordship, where I have mistakenly made a party to
No, your file is passed.
Lordship. No,
Is the IA is it without defects?
yes,
Have you
Lordship.
checked? It is without defect. When is the next date of the writ petition fixed?
27 February, Lordship.
You want it prior to that?
Lordship, then I have
Why?
to file Lordship, cost title, amended cost title on that day, Lordship, before the listing of this.
Make a mention on Monday before the appropriate bench. Ki maji didibo paron ki? Aji senior bench na hai pai. Let him check. If there is no senior bench, we'll have it.
Right, Lordship. Monday.
May I please, your lordship? I'm praying for the listing, lordship.
Start. What is the matter? WBC.
WPC, Lordship.
There is another bench. Two benches are there.
I'm extremely sorry, Lordship.
Lordship, same.
Two senior benches are there. You try your luck there.
Meet with the Lordship.
In this case, my lord, petitioner filed this case because of non-payment of salaries. As per court
Non-payment
order,
of
my lord,
salaries prior to the date of your regularization.
regulation, and speaking order has been passed by this director, my lord, which is effect 2009.
Now
But-
they are moving an additional affidavit saying that we want to
Revisit.
defy that order.
Yes.
Yes, my lord, because it is not possible because they should go to for review, my lord, instead of revisit the.
Matter is pending. Should I allow the review or not is the issue now. Should I allow them to review or not to allow them to review? They have prayed before this court. Not prayed, they have submitted before this
Submitted before
court
the
that
by way of filing affidavit,
uh,
my lord.
since the matter is pending,
Yes.
we do not have
No,
the
it is now pending, but earlier too, it was pending, not pending, my
Not
lord.
pending.
Yes, at that time
that-
they could come earlier, my lord.
Ah,
But I have filed contempt also. In contempt also, lordship.
they
could
did not
prepare-
take that plea.
No. Contempt also, it is stated that if he would get salaries and area salaries, they should get within a period of 120 days or something like that.
Ah,
Pays, my lord.
then it was
The
closed.
thing is,
My lord, as per director speaking order also, it is not mentioned, specifically mentioned that he has to pay the salary or he has regularized on from 2/3/2009. But it is misconstrued by,
That mistake will be to their advantage.
it was
Every time
misconstrued
we
by
find,
the.
every time the petitioner finds a fault in your order, if we allow you to keep reviewing the orders, he has to come back after 2024. And this review part, you did not take up in the original affidavit.
yes.
Once you were caught on the wrong foot, perhaps during the arguments, that where is that sentence? Then in a hurry, you say, okay, we'll file an affidavit because that was not recorded in the order.
But in last affidavit, we have filed as a additional affidavit, it is mentioned here that we want to revisit the speaking order.
Order has been passed long back, my lord, 3rd October 2017. They could have been come earlier. Against,
Now, madam,
against
you
for review,
convince us
review.
from 17 to 24. How do we overcome Horen Bormon? Horendranath Bormon or something
Yes.
is there. The 3 years
Constant.
limitation is there. How do we overcome that path?
Horen Bormon.
Harendra Chandra.
Harendra Chandra?
Not.
Not.
That is Sabole, much one.
Huh?
I have not gone through it.
Today we fixed it for disposal.
Yes, my lord.
To decide the whole.
Time may be granted so that we can file our.
You have taken that stand in your affidavit in opposition. Therefore, I am putting the question to madam.
Yes.
That stand that 3 years have passed, Tarsem Singh.
Yes,
Yes,
Tarsem
yes,
Singh,
yeah.
they have stated, yes.
That they have taken the ground and in your,
They never
in your
said to
reply, have you
revisit.
said anything as to why you should be paid despite Tarsem Singh? Tell us that much only.
Petitioner got relief, my lord, since 2017, my lord.
Huh?
He has been regularly paid, but it is, since it is, effect is 2009, so
Where is the effect is 2009? Show us
it is,
that.
yes, my lord, speaking order, lordship,
Where is that
last order,
page?
page 80. With the above facts, facts and perusal, the service of the Khoghen daughter, who has been working as casual employee in the office of the inspector school, Nalbari, the authority, the secondary education is decided to pass the order for regularization of service and of the petitioner Khoghen daughter against the vacant post of Gate 4 post in the office of the inspector school NDC Nalbari due to upgradation of Ratul Kumar Sharma on to the post of junior assistant in Garment Gordon High Secondary School, Nalbari, 2/3/2009.
On 2/3/2009.
Because on 2/3/2009, my lord,
With
Ratul was,
It is with effect from 2/3/2009. It is on.
Now you have given the benefit under the notification of 26/6/2013. The paragraph before that, kindly come to the paragraph before that. Whereas in pursuance of government letter number 17 and in compliance of honorable court order dated 27/2/17,
17.
This office has re-examined the matter of the petition and found that he will be entitled to the benefits of the notification dated 26/6/13.
13.
Is it not?
Yes.
My lord, regarding that, my lord, one criteria.
What is 26/6/13? There is a notification, some notification.
Maybe.
We have that notification, madam.
No, I don't have. Asset not allowed. Put this up.
26/6/13
Uh-huh,
notification do you have?
Yes.
It is 27 June 2013.
Please show us that.
Paste.
Page 121, Annexure D, ma'am.
Nalage anibo, yaar ase.
Yes,
Affidavit.
yes.
121.
Position.
That is
An
peace
affidavit
memorandum.
is filed by the respondent director. 121.
15. 27 June 13.
But petitioner has not fulfilled the criteria, first criteria.
Oh, that is your problem. Once you pass an order, regularize her, now you will not come back to say that she did not fulfill this, did not fulfill that. Sorry. If you want to do that, give her a notice, let her reply. Before the reply, let her take all other avenues possible and then decide whether you can cancel that order or not. That order was passed in pursuance of an order of this court.
Yes.
Yes.
To your benefit, we must presume that you had taken everything into account. The moment we say you have passed an order without taking something into account, you have acted mechanically after orders of this court. Acting mechanically will again become a case of partial disobedience. Is it not?
Yes.
Should we go into that now? Let us not travel in that direction.
They never denied that I have not
Just
been
a minute.
working like that. I'm continuously working.
Who appears for the finance? Mr. Cholia, just tell us one thing. This 27 June 13 is your document.
Lordship, the notification. Yes,
10 years, this,
Yes,
that, no?
yes.
Open the, no, but the 27/3, 27/6.
Lordship.
People have been regularized elsewhere also under this notification.
No, Lordship, on the basis of this, regularization has not been done, Lordship.
Listen to our question, we'll have a
Lordship.
shorter, sweeter answer. 27/6/2013, you have already, some departments have regularized.
Yes, Lordship.
Those people's salaries have been paid.
Lordship.
Whether they have been paid prospective to the
Notification.
regularization
Lordship, yes.
from the date of the notification
Lordship.
or from the date it was taken into account,
Lordship.
that 10 years,
Lordship.
from when did it start?
Yes, Lordship.
Was that taken into account? Was area taken into account?
Lordship.
Can you give us that?
That I can find out, Lordship.
Please find out, let us know.
Lordship.
Now, today we are disposing this off.
Lordship. Lordship.
Okay.
Yes.
Now,
yes.
if further notification, you have acted that others have all received salary from the date of their provincialization,
Lordship.
the claim of the petitioner will be evaluated in that manner.
Lordship.
If you have given the benefit from the date of the notification,
Lordship.
it will be from that manner.
Lordship.
If the 10-year service taken into account, arrears have been given,
Yes, Lordship.
we go for arrears.
Lordship. Then the petitioner will be.
Is it not?
Yes, Lordship.
Yes.
And because, see, we could have gone for Harendra Chandranath also.
Lordship.
Every of the officers of their department
Lordship.
have given the calculation from
Long back.
2009.
Lordship. Yes.
So they have almost admitted that it is 2009.
Lordship.
It
Lordship.
is almost an admission.
Lordship.
Is it not?
Yes, Lordship.
So those 3 years period in different cases of this court has
Yes,
been
sir.
held
Yes.
from the date of application, date of crime,
Yes.
not from the date of the repetition, but the date of the first representation. This is
Lordship.
what everybody has done
Yes.
in this court. Now, when was your first representation, madam?
First sleeping.
That I should get 2009?
Yes.
2009 is not the date of your regularization. 2009 is the date when Ratul Sharma was upgraded.
Upgraded,
That
yes.
post felt vacant. That
Actually,
is not,
yes.
that is not important.
Initially, he was working on leave vacancy continuously.
in this,
Then
that will not be important.
No, I approached this honorable court, then honorable court passed an order to make make payment on in contingency fund, my lord. But at that time, contingency fund appointment was banned.
Now, when you filed a writ petition,
Huh,
they talked
First one.
about the regularization.
yes.
He will be entitled to the benefits of the notification dated 26/6/13. It should be 27/6/13. Okay, spelling mistake
Yes,
corrected.
that is.
Now, please, Mr.
So,
Soliha, you tell us today.
Yes, Lordship. I'll get that instruction, Lordship.
Because the first order, this calculation part
First order is 2005.
comes in 2022. When is your first letter, madam?
Representation.
Eh? Saying that please pay me.
That is page 55,
No,
where for regulation of service.
no. After
2004.
25, everything,
After
many things
25.
flowed. You got your regularization in 17.
Yes, 17. Yes.
After 17, when did you first say, give me arrears?
Yes, sir.
Oh, yes, yes.
That is what we are asking. Hmm?
29.
Next করা নাই আছে মোৰ লগত find out in the I have not annexed, my lord.
When was your regularization order?
Speaking order, lordships.
This court passed an order in 2020.
There are lots
Again,
of
the
court
top
order, my lord.
again,
Yeah,
29/9/2023.
2, 3.
So Soliha's
After, my lord,
instruction may help us.
Lordship.
We may not go so deep into that.
Yes, Lordship.
There might have been some writ petitions which says that no, on regularization, I should get it from that time.
Yes, Lordship.
This court may have decided an issue that if you're regularized under this notification, salary starts from this time.
Yes, Lordship.
That will cover it. We can give a particular date. This is the date. Date of the order,
Lord.
date of the this, date of the that. Huh?
Yes. I'll
We
just.
have the restriction. We want to dispose this of
Lordship.
অলপ পিছত মাতি দিয়ক এই চলিহাই হেৰি লৈ আহিলে ইনষ্ট্ৰাকচনটো পালি
the timing.
One order is passed by the inspector of school on 11/10/2017 for regularization. Here it is stated, in pursuance of order of Director of Secondary Education, Assam, Kahalipara, Gauhati 19, by memo number so and so dated 3 October 2017, the service of Khogen Datta, who has been working as casual employee in office of the inspector school, and this in Nalbari is hereby regularized against the vacant post of grade 4, Vice Ratul Kumar
So give
Sharma.
me a case law, sir, that when it is said that it is regularized hereby, the salary starts on that day. Or it starts from the date on which his service has been taken into account for regularization. Matter ends. They will
First
be,
line, it is stated, as such, the Khogen Datta is hereby allowed to act as grade 4 in the office of the undersigned with effect from 2
Again, picture.
to 3 2000.
Mr. Choliha, take the pen. I will get tired up in the first half an hour otherwise.
Just get there.
Please, what? What is your case?
The matter is arrear salary of the retired teacher of Lordship.
What had happened?
In this case, your Lordship, petitioner Initially, he was appointed assistant teacher of a school. Subsequently, he was promoted to headmaster. And during his period of headmaster at Jogirpam AHS school, he was arrested by police in connection with a criminal case on 21/20/25.
Hmm.
And thereafter, he was suspended from 6/5/22 after 4 months of his arrest, page 16 of this order, Your Lordship.
Hmm.
After that, that suspension is regularized, reinstated, Your Lordship, page
Regularization order,
reinstated order, Your Lordship, page 20. He has reinstated on page 20,
page
20.
Hmm.
Reinstated. After that, that criminal case also, he got acquittal, Your Lordship.
Just a minute. No, regularize is not that order.
Regularize,
Page 20 is the reinstatement.
Regularized order, Your Lordship, page 40.
What is this WPC 1286 of 19?
Wanted, Your Lordship, his
Ah.
he filed this petition with a paper directing the.
Was there any
regulatory-
departmental proceeding?
No, yeah, there is no dependent.
There is no departmental proceeding. Then
After
after
that-
what happened?
After that, Your Lordship,
2022, the acquittal came.
22. Acquitted, yeah, he got acquitted.
Acquittal?
Acquitted, he got acquitted.
Clean.
Thought so. Judgment is page 24, relevant portion page 34. Yeah. The first case was initiated against the president and headmaster of the school that they had sold out the recipients of fund by the. Page 34 is the order.
Hmm.
After that,
Then you file another writ petition.
writ petition.
What happened there?
That writ petition, Your Lordship, page 38, the order you have that is filed. Relevant portion page 38, if claim for all page 38, last paragraph. Direct the petitioner to have a representation for the inspector school. Regulation or suspension period. Effect from so and so, so and so. And after the page 40, suspension period is regularized. Regularized only for pension beneficiaries, 15/7/2022. And these are the area views of that period. Your Lordship, me turn to my affidavit and reply. I have annexed all documents. Page 75. 24 years. Running page 74. Your Lordship got it. In the meantime, he is retired from service on Minister of Service, Your Lordship, 1/2/2023.
Who is the person who suspends him? His appointing authority is whom? Ah, assistant teacher,
Director.
director.
Thanks.
How can the inspector regularize it for all purposes whatsoever? Is it a order without authority?
I think it is that is page 76, the order.
And here it has been done, this 15/7/2022 is only for pensionary benefit. It has not been done for all purposes.
After acquittal from criminal proceeding.
Ah,
it's
for
after-
pensionary purposes.
Earlier. Subsequently.
Thereafter, which order?
Subsequent page 76. Running
Page?
page 76. That order is modified.
We don't have a 76. Oh,
The running page, yes. Everybody in reply, others. Running page. 9/12/2022.
no. You first show us that there is an order regularizing your period of suspension as spent on duty for all purposes. Where is that order?
Page 76, sir.
Page
76, running
76.
page 76. AVT in reply of my AVT in reply. Got it.
Where is the order dated 13/6/202?
Is 36, you registered on operating
Ah.
portion 38. Date condition.
71, that's number 71.
Hmm. Who is this person who has signed this order? 9/12/2022.
It is inspector, man.
Please read page 39.
In in the event of filing any such representation by the petitioner which within the time as directed above, the Director of Secondary Education Assam, after considering the relevant record and documents as well as the departmental proceedings, if any, against him, and shall dispose of the said representation of the petitioner with a reasoned order within a period of 60 days from the date of receipt of such representation from the petitioner, intimating him about the outcome of the same.
Who should have passed the order regularization?
Director,
Who has reviewed it?
but it was passed by the inspector of school.
Was it permissible in view of what
No,
the court had said? And was it permissible in view of the affidavit filed by you? Who is this particular officer who has signed it? How did he have the authority? Where did he get the authority? He is not the appointing authority.
yes,
He is not the disciplinary authority.
yes,
He is not the person named in the order.
no.
And he happily says, in compliance of High Court order, I am regularizing it for all purposes. Our shoulders are broad, our hands are long, but our shoulders are not so broad that we will take up the burdens given to us by the inspector of schools. The inspector of school, he must be his duty somewhere today. Sir,
So, madam, sometime may be granted so that I can get the reply from.
sometime, no sometime. Talk to your officer.
Yes,
12:30 VC.
yes,
It's a VC.
yes.
Any office, he will sit down, put on his mobile. He will tell you. In compliance. How could he take the compliance when the order required the Director of Secondary Education? He is not the disciplinary authority. He is not the competent authority. He is not required by the High Court to do anything. Number one. Number two, the Director of Secondary Education. Why no order was passed? Now we have a feeling why courts are loath in passing orders, why the courts are slow in passing orders, directions. Because the sentence comes in compliance of Honorable High Court order, and one person does not look into the earlier orders of this court. There is a big turn around in the field level. Do you see? The name of the authority signing is not there. Huh? Now kindly look at the earlier order at page 40.
Yes, 40, yes.
Big beautiful names.
Yes.
One person responsible. Is it not?
Yes.
At 12:30, get it on your WhatsApp. We'll assist you by giving you a printout from here. No difficulty. All the file notings, the entire PDF of the file, which led to passing of the order dated 9/12/2022.
9/12/2026.
Yes, sir. Reply.
Okay?
Reply.
Whether the Director of Secondary Education asks the Inspector of Schools to do so. If the Inspector of Schools have had the authority from the Director of Secondary Education, why so? When the court required the Director to do so. Okay. Saturdays are going to be bit difficult to find little bit. And yes, sir,
Yes.
you also tell us how suddenly there is an order
No, your lordship, and
and
as
the
per
court
my
proceedings are
instruction,
on.
as per instruction, your lordship, his, after the High Court's order, your lordship, dispose of, he submitted representation. The High Court also said that with, through the inspector of his school,
Ah,
submitted representation, he submitted representation before that inspector.
that was disposed
Therefore,
of by what? That was disposed of by the order dated 15/7/2022.
Lordship,
Is it not?
lordship,
Then you file another representation.
lord,
Give me this money. Is it not?
that,
Huh?
that order, your lordship,
This was filed on
page 38. your
15/10/2022.
Page 38, Calipari, sir.
Huh?
Page 38,
Ah,
High Court's order, your lordship.
yes.
That the petition,
Then page 40 came.
direct the petitioner submitted represent before the director of secondary school through the inspector of school Barpeta. I have submitted inspector of school Barpeta's representation, they forwarded to the director. After as per
Kindly
instruction,
see, this order is of 13/6/2022. Is it not?
lordship,
Where is your representation?
representation is not annexed, your lordship, he submitted before the
Date?
inspector. Date also he is forget, he is not.
Where
copy
is the
not-
date?
Copy is not with him, your lordship, but he submitted that before the inspector forwarded the director and
Oof.
conducted hearing also there, as per my instruction. Director conducted hearing upon the petitioner also.
See, please see again.
Yes.
This is what happens. 13/6/2022,
Sir,
order of the court
40 years.
to give a representation again within what time?
I think not
No,
very-
already two representation has already given by him. As those representation of the petitioner dated 8/4/2022 and 11/4/2022 are pending for the disposal before the inspector of school. Page 38. Second last paragraph. Barpeta, District Circle Barpeta. The petitioner has preferred this writ petition. After hearing the learned counsel for the parties and considering the entire.
Just a minute. Page 38, last paragraph.
Yes.
Read it.
After hearing the learned counsels for the parties and the considering the entire aspects of the matter, this writ petition is disposed of at the motion stage itself, directing the petitioner to submit a representation before the Director, Secondary Education, Assam, through the Inspector of Schools, Borpeta, District Circle, Borpeta, on or before
Mark that. On or before?
36/2022.
Right. Now come to page 40. What is the date of that order?
15/7/2022.
Now come to page 45.
Yes.
What is the date?
15/10/2020.
What is the last line? Last line of page 45.
That though though the inspector of school Borpeta Circle, Borpeta by order dated 15/7/2022.
Just a minute. This representation is after the orders of the IS
Yes.
by regularizing his services only for pensionary benefit. The time given by the court was 36/2022. So
Yes.
this representation is beyond time. Correct?
Yes.
Now, suppose the inspector of school has received a representation, he cannot sit over it. He was required to forward it to the, as per the order, forward it to the director of secondary education, who was required to have passed an order.
Yes.
Is it?
Yes.
Now page 76. This petition was filed when?
Yes.
So 23.
1st of December 2022.
Yes.
Page 76, 9th of December 2022.
Yes.
Regularizing for all purposes by reviewing the earlier order. Signature of the person remains the same. Never forwarded to the director of secondary education.
Yes.
Claim is somewhere around 22 lakhs. In the affidavit, director says, what? That the regularization has been done without going through. Shall we read that sentence to you? Mr. Sharma, please be assured we have not come prepared with anything. We have just been running the pages here. Is it not? Now, please come to
Yes, my lord. It is stated here.
where is that repeat? I am not the repeat. I'm on the affidavit in opposition. Please have the affidavit in opposition.
Page 51.
Page 50.
Page
Ah,
47.
page 52.
Yes.
Here, para 11.
Yes. The Assembly begs to state that order dated 9/12/2022 issued by the Inspector of School NDC Borpeta is a mechanical order, as it was issued without evaluation of the rule as referred in FR 54B3. Furthermore, there is no indication that any competent authority has recorded that suspension of the writ petitioner was wholly unjustified. The petitioner.
Just you. Have you got a gist of what this court is feeling now? Why the order dated 9/12/2022? Huh? Kindly find out the relevant officer. Kindly have your DSC instructed, Director of Secondary Education instructed. The convenient time today during the first half when she would be available on VC along with the officer concerned. We don't want to disturb her office proceedings, neither for the inspector of schools who passed an order when not required to do so, neither the DSC who has said that my officer is wrong. Now do what is. We will require those, we only need to hear from them because they have not been able to give you the instruction. The Sharma with some appropriate instructions would have created havoc in the court. We are sure of that. But Sharma is now made a gladiator without arms. Action. Let the referees come. Tell us, we'll take it out of the subject. But this has to be sorted out. Unless people who are passing orders understand that orders frame the very basis of a claim. Orders are not to be passed away. We will leave it to the wisdom of your department. Corrections. Not find anything in this petition except directing the Director of Secondary Education, since sitting today. We call for all the records, pass a order within the next 2 days as to what is to be done to your suspension. Same not being done within the next 2-3 days. We have accommodation here with a table and a bench, and people will sit here and then start writing off. We will not have the senior officers, we will have the persons who put up the file. We'll give them a bench and a table. They'll make the notings here, have it vetted, forwarded. If that is what is required to be done in this department. After some time, kindly inform the court master the time when we can have this kind of a. Next. It you have bill to know how to? Ah, yes. 4 and 5. There were 2 writ petitions. Yes.
That matter, that downgradation from that headmaster to assistant headmaster.
Ah,
So I have prepared one list
I
of
forgot.
list of lordship,
Little help will do.
list of dates lordship.
Secretary as the school management, petitioner joined as the in persons of the appointment letter. What were you appointed as?
I was initially appointed as assistant teacher.
Assistant teacher was appointed by the secretary. See, this is how the synopsis can help when you give the initial position. Then
Lordship.
petitioner joined services. Then
Thanks, sir.
acquaintance shows petitioner received FC grant. What is FC grant?
FC also financial grant lordship.
FC?
Financial grants. Because the initially the school was-
Provincialized order, petitioner was also provincialized. Then
Yes, lordship. Thereafter lordship
after provincialization, your appointment was approved.
approved. Approved.
Your earlier appointment,
Lordship.
the appointment by the school.
School committee.
Okay, then
Thereafter lordship
then on 1st of October, you were confirmed.
confirmed lordship.
After provincialization, a confirmation is required, sir.
When I have annexed lordship, I don't know earlier, I think.
Ah,
Lordship
just a minute.
required lordship. Finally, lordship,
Burwa is senior teacher to Mohendra Datta, seniority list prepared, clearly with petitioner, date of joining is Iman.
lordship India 2017 lordship, he participated lordship.
Ah, that minor, that whether the initial date of joining was manipulated.
Yes, yes. lordship,
Okay.
regarding that lordship. India 2017 lordship, he was promoted lordship to the headmaster position lordship. Thereafter lordship, a report dated 4/10/2017 lordship was there lordship by the inspector of school lordship. That is, thereafter lordship, show cause notice was issued to me on lordship on 6/9/2018. Seeking explanation regarding lordship, the manipulation lordship.
We are not understanding page 5 of your synopsis.
Lordship.
16/11/2023. Just a minute. You filed the writ petition on 10/11/2023, maybe 9 or 8.
Lordship.
Page 4, last line.
Lordship.
11/10, your order is cancelled.
Yes, lordship.
You approached this court on 10/11. Court said, do not promote anybody.
Lordship.
Do not process. Thereafter, 16/11 date is okay.
Lordship.
Petitioner went and submitted that. After that, 4/11 and 8/11, why?
Lordship, because
We should come prior to that.
prior to that lordship. In the, it is my mistake, lordship, in the this update lordship. That is annexed by the learned friend in the lordship of affidavit in opposition lordship. That's why lordship. Thereafter lordship, disciplinary proceeding was concluded lordship by the impugn order lordship 8/11/2023 lordship. Lordship,
Yes, what do you have to say?
No, Lordship, as I have submitted earlier also, Lordship, that disciplinary proceeding, whether not from my mouth, from court's observation, that it is vitiated, Lordship, from that point, Lordship, when that impugn order was passed, because it is dehoves the Rule 9 of the Assam
We have that
Services
record also.
proceeding. I have sent the record.
Hmm.
From the record, we have seen that till appointment of inquiry officer and presenting officer, it was okay. On the next day, notice was.
Inquiry took place?
No, on the next day, Lordship, after appointing inquiry officer, notice was sent to all
Concerned,
witnesses and
everybody
concerned
came.
to attend the hearing.
He gave a statement and
He
then
gave
there
his
was an
statement
inquiry report.
And on that same day, that inquiry was concluded. The holding that he has manipulated the date of birth, sorry, date of joining in the school.
And date of joining manipulation, what this court was of the opinion is that he originally joined on 10/10/1990.
Yes, but
And therefore, whatever was given in that approval order or whatever, he went back to say that no, it was 10/10/90, so he might have manipulated
might have
it.
been joined.
But even if that manipulation is taken into account, it is not something wrong. Something admitted by the approval order.
Yes, from the approval, but Lordship, in
Now,
approval order.
what is the approval? Where is the approval order?
Approval order, page 39.
39.
9. Lordship, got it? In persons of the order of director dated so and so, it is hereby made order.
Where did he get this date from? 1911-91?
Lordship, it was date of
with
his-
effect from Lordship,
with effect from.
he was.
Where is it?
Lordship.
Where does that with effect from comes in?
On the date of provincialization, Lordship, that is the date.
That is date of provincialization.
How could he approve something?
Yes, Lordship.
10/10/1990?
And that, Lordship,
10/10/1990 was the date on which he was
appointed by the.
appointed, and it is on basis of that date he was already provincialized. Is it not? Sometime in 1991.
Yes, yes. No,
Thereafter, this approval comes.
Yes.
Approval of
That approval had to be of the initial
Still,
appointment, could not have been of the provincialization. Provincialization order is by the government.
yes.
Who is the inspector to approve it?
all the Lordship teaching staffs has been approved.
But who manipulated it? You.
No, Lordship. Lordship, the allegation is that I have manipulated the.
You have done it. Who has done it?
Lordship,
Who put in 10/10/91? You put it.
Lordship, this is the allegation, Lordship, but the initial appointment, Lordship, was 1990, Lordship.
Who wrote that 10/10/90?
That is the allegation that against me, Lordship.
Someone else has written it.
No.
The allegation is against me, Lordship. But I have the explanation that
We were just trying to find out how you deal with that situation. We will not go into that.
regarding that.
Okay,
I
so
have-
we'll dispose this off today.
Lordship,
Your
Yes,
matter
I-
done, madam?
Lordship, granting.
Your matter done? And you are at item number?
So regarding that, I am.
Lordship, granting
We'll
liberty.
pass the,
Lordship, granting liberty to department by conducting the inquiry from their stage by appointing a inquiry officer. Lordship has earlier expressed.
there will be, there may be a liberty, but that liberty will be with some conditions.
Lordship.
It will be with some conditions. Persons who do not know how to hold a disciplinary
Yes, yes.
proceeding will not be a part of the disciplinary
Gotcha.
inquiry, number one.
Lordship.
Number two, the department will keep in mind the fact that it was the date of appointment original, 10/10/1991,
Yes, yes. That,
which ought to have been approved.
Lordship,
And that date of appointment
Lordship,
of 1991
yes,
is not something which is beyond records.
yes. That the two aspect, Lordship. First,
Right? So, a knowing misconduct to take a benefit
Lordship,
and an error in doing something, a mistake in doing something which ought not to have been done,
Lordship.
the wrong way of doing the right thing
Yes,
and the right way of doing the wrong thing. So here is a case we find it is the wrong way of doing the right thing.
Lordship, two aspect here.
And that would perhaps not have the impact of taking away his services or his seniority so as to debar him from becoming a headmaster.
Lordship, equitable, Lordship. That
A
equitable.
censure,
Lordship.
you have seen the level of mistakes being made by the inspector of schools. Is it not?
Lordship.
To the person who I do not know, what is your qualification?
Lordship, BHC, Lordship.
Huh?
BHC Royal, Lordship.
Physics, chemistry, and
Physics,
mathematics.
chemistry.
Still,
Anyway, in that point of
In
time,
that point of time, Lordship.
you will dispose it of after we hear Miss so-and-so.
Lordship,
We'll pass an order.
may I
You-
take leave, Lordship?
Yes, we'll record your presence, we'll record your submission of records.
Lordship.
We will record your vehement opposition to the writ petition.
Lordship.
Is it?
Lordship, there is a order for reinstatement also, Lordship, in the earlier litigation, Lordship.
That is why we were asking you for that particular this thing.
Lordship.
If the reinstatement comes, if that order goes,
Lordship.
then it was upon you to have filed an appropriate application before this court to inform that yes, or someone else has already been appointed. And that was not in my knowledge when we moved the writ petition, but it has already, someone has been appointed.
Lordship.
So please keep the appointment subject to outcome of the writ petition. Otherwise, we would suffer. Therefore, we are also making the other person a party respondent because his headmastership will go. Did you do all that?
No, Lordship, but
No.
there is order for Lordship not to.
You will be
finalize.
accommodated as a headmaster if your promotion was correct,
Correct.
wherever a vacancy is available. We
Lordship,
do not know.
one thing just I pointed out, in the disciplinary authority, it ought not to have been the consideration of that disciplinary authority, what is the actual date of birth.
Right.
They would have to confine whether the misconduct was committed by a petitioner or not. But this was go beyond,
They went beyond.
they went beyond, Lordship.
And even if it is taken to be even if their date is taken to be the correct one, even then he is senior.
Senior, Lordship.
Why should his headmastership go? The punishment would be dismissal from service, manipulation of
So
record.
my pair before,
You are
Lordship.
taking down a headmastership, allowing someone to sit up.
Yes. So
But
my,
he says allegation. Maybe the other person signed it.
yes. For that, another fact finding inquiry was required, Lordship,
Eh,
for determining the actual date of hearing. But in the discipline authority, they have went in that to find out what is the date of joining, Lordship. It was not the purview of the misconduct or discipline authority.
Whether there is a manipulation or
Lordship
not,
may
and
clarify on
whether
that.
he did it or not.
Lordship may clarify on that point, my
That is the
pair.
only thing required to be done.
So their scope of disciplinary proceeding also be
Limited.
clarified, Lordship.
Limited.
Limited.
Or you want to say delimited,
No.
limited.
Lordship.
We'll see what we can,
Lordship.
once we start dictating the order, we'll see the problems coming up.
Lordship.
We'll try
Deal
to
with
solve
it.
as much as we can.
Obliged, Lordship.
Lordship. And one
Only for
point,
presence to Lothar, Mr. Swenso and Mr. P.P. Dutta. তাৰপিছতে মই অৰ্ডাৰটো আজি কোৰ্টতে ইয়াতে ডিক্টেশ্যন দিম অলপ দেৰিকে দিম মই মেডামক ফ্ৰী কৰি দিম We'll dictate it, you be here by around 12:30. We'll start your dictation.
Obliged.
Yes, madam. এইটো জাজমেন্ট কোনে দিলে তেখেতে দিলে নেকি পেটিশনাৰে দিছে কোনটো কেছত এখন WBC দিছে Yes, madam, that day we had put some specific questions to the person
yes.
attending the court. Are we armed with the answers? Kindly tell us.
Before we start, my brother has given an additional affidavit.
Yes.
So since copy has been served to upon us, I have sent it to branch for parawise reply. But it is not yet completed, but to that effect, there is no as such order. So if your honorable court
We
will
are not
take
giving any more time.
cognizance of the additional affidavit that we need to have reply.
Well, we just need to, the additional affidavit, have you gone through it? Can
Yes,
there be a parawise comments to this?
yes. I need to file parawise comment.
Well-
It is ready, but it is not yet approved by the higher authority.
Just tell me one thing, madam. The additional affidavit you have gone through,
Yes,
let us have a copy of, if you have a copy, kindly go through it.
but it was not approved.
Where is, huh?
I have the copy. They
Please
given
have
me.
the copy in your hand. We will see whether you need to reply to this and whether we
Yes,
need to
yes.
take into account the affidavit and reply at all.
It's the trial court's order.
Where is that? What page does it start, sir? The additional affidavit?
May I please, my lord? My lord, so far the affidavits are concerned, I have just annexed the particular,
I'm asking you, where is that affidavit in reply annexed? What is the page number?
oh, page number 301.
It is in
30?
record. It has attached to the record.
Last time also we had indicated the
That it
affidavit
was
is on,
not
not on record. Today
That's
also
fine.
no effort has been made to bring it on record. What can we do? It is not on record.
It was filed.
I made it,
Yes, yes,
I
yes,
observed that
yes,
it is
yes.
not on
Yeah,
record on the last occasion.
So we again proceeded and they said that it will be on record.
The খবর করকচোন এটুত খবর করক
It was filed on
Affidavit.
31/2000.
there is an affidavit in additional affidavit filed in this case. Why is it not on record? তেওঁলোকে খবৰ কৰিছে পঠিয়াই দিম বুলি কৈছে আজি কেছটো লিষ্টত আছে আহা নাই kindly give us slip
Clearly.
kindly give us slip now madam we do not go into that part of the additional affidavit for the time being.
Just I am apprising your lordship, this is the situation.
Our questions were like this. Do you dispute the notification or can you dispute the notification which was given by the government of Manipur saying that after the arrest of the person, there have been protests and at 11:45 in the night, we shut down the internet for 5 days. Can that be disputed?
Yes, there is a one notification with regard to only data, not to the leased line, not to the leased line and Wi-Fi. In notification, it is only internet, not to the leased line or Wi-Fi.
So that
So Wi-Fi is going on and the accused person has given the number. We have called them. We have given a message. There was a double tick. To copy of which I have given on the last occasion. It must be in the record. There is a double tick. Double tick shows it is delivered. And there is
delivery of
disconnection.
a notice by WhatsApp
Yes,
under
sir.
section
The
47.
number given by the
Has
accused.
it been dealt with by some court saying that that would be a proper mode of?
So the situation is like that. There anarchy is going on. All were
Now, if
disturbance.
the moment you say that the Wi-Fi was there,
Yes.
you admit that it was after the arrest of the particular person concerned that the internet was shut down? Only the internet was shut down,
Yes.
not the Wi-Fi.
Now, since notification is there, it is up to them when they have disconnected. Or there may be a delay part.
Let me be clear again.
Yes. But because
It was because of the protests which came into existence because of the arrest of the petitioner that the internet was disconnected without, of course, touching the Wi-Fi and other part of it.
and leased line. There is
And the
leased
leased line which learns the Wi-Fi. And there were methods by which you could inform the family. The only number was given by him and you informed immediately.
And accused admitted that he is having Wi-Fi.
Very good.
To that
It was after the arrest of the person that the other internet services were shut down. That was on the 7th. Your arrest memo says 8.
8. It is a matter of record.
And the man was arrested on the 8th in the airport because they had specific information.
Yes.
On 7th, the man was already in custody. Of whom? For that objections, that rioting to start. In whose custody was he? By whom was he dropped to the airport? And how did your arresting authorities then arrest him?
Lordship, these are the matter of trial.
No. When the man is arrested on the 7th and the memo of arrest shows 8th, and then he is not produced before anybody because already there is a rioting going on. And you produce him at Gauhati, not at the nearest magistrate. When there is a commandant in the airport of a designation who holds the power of a magistrate under the CISF Act itself.
But that too, nobody has
The
started.
arrest is vitiated. We are not saying that the arrest
But
was
looking to the
unnecessary.
scenario, it is very difficult. Nobody is coming out.
Not on that, madam. Again, please let me go back. Because of his arrest on 7th, the rioting took place, the protest took place.
Yes.
Wi-Fi, let us assume they had the means to send it by Wi-Fi, leased line, whatever line they could. Arrest was on 7th,
As per them.
no, as per the notification of the government. That is the problem. The government notification says this man is arrested. There is a halabu. We are shutting down the lines. And your officers say, someone told us he is in the airport. On the 8th, morning we reached. We arrested him. Now, you arrested him, you don't show the time. There are few flights from Manipur. So you need to book the tickets, get the security check done in. With a person in your custody. To fly to Gauhati, what time were the tickets booked? Was it booked on 7th for 3 persons? Knowing that tomorrow morning we'll arrest him.
To that effect, so
Uh,
far, so
This is important, this is not important whether he is guilty of the offenses alleged or for which he has been arrested. We will not comment on that. We are sure the trial will take care of it. All matters have been transferred to Gauhati to ensure that there is a proper. We do not for a minute doubt that the trial will take care of it. We take your submission. Convince us
yes.
that the arresting authority at that particular point of time did not manipulate any known fact to them to uphold the continued detention when the arrest appears to be faulty. The arrest has to be, you will run away. You will now make the crowd go mad. You will take away all these things. 2 persons have identified you. You were looting that particular battalion. We have particular information, sir. We need to keep you in custody. Please come with us. That is arrest. Now, when you tell him these things, why are the grounds made known? He knows what is happening around him. If this court is under now an impression that the arrest being on 7th, documents prepared to show it was on the 8th. Now, if he has been arrested on 7th, if the government notification is to be believed, 11:45, the decision to shut down internet. Prior to that, 2-3 hours, something must have happened. It takes a time to decide. One will not do it in 5 minutes. Prior to that 2-3 hours, his arrest has to be circulated.
Yes.
2-3 hours before that.
Before.
4:30 or 5 in the evening, the arrest news spreads. You produce him on the 8th at 4:30 here. Right? 7th, if he is arrested at 3 o'clock. Documents to show that we are arresting on the 8th without mentioning the time. Producing at 4:30, 24 hours, 1 hour more than the 24 hours, the arrest becomes faulty.
But the CD will reflect that when they have arrested and everything.
Tell us.
CD.
Tell us. Flag the pages. In the earlier occasion also, whatever pages you flagged, madam, was it reflected in the judgment? We reflected everything. We'll reflect it. But the issue is, we are only to decide whether the arrest becomes vitiated. Not commenting for once on the assumption of guilt by the prosecution or the investigating authority. They may be entirely correct in doing so. He may be a man who is required to face a trial. But the arrest part under 47-48 and the manipulation attempted in the records. Till now, what we have seen, we have not heard you. We just want to be clarified on that point. Once you clarify us, then 47, 48, 22, 1, everything we can deal with. No difficulty at all. But when the notification says arrested on 7th, internet stopped on 7th, presumption, the arrest is on 7th. He is in custody. The statement of the arresting authorities to the effect that he has been arrested on 8th on specific instructions when he was trying to run away. They did not have the tickets. They did not know the man would be there or not. So they have to enter the airport. some official communication. Without an official communication, you cannot enter the airport.
To that effect, I have one submission, Your
Yes,
Lordship.
yes.
For any investigating agency,
Ah.
they have certain emergency quota
Mm-hmm.
because they will have to move fast.
Was.
Emergency quota.
To us.
So showing the identity card.
To
and
us. You had
everything.
the petition before you. You had the time 7th I was arrested statement before you. You had the statement before you saying that yes, we arrested him on 8th. We could not produce him before anybody. We kept him waiting in that
Yes.
inside the airport, and it is not outside the airport in the parking area. It is inside the airport. We entered after telling the commandant of the CISF, we need to enter, that man we need to arrest. There must be a communication. The tickets must have been made at a particular point of time. Awaited the flight and boarded.
Yes.
Tell us.
Emergency quotas are there.
Tell us.
Any moment
us.
they can move.
Tell us. We had
Under such situation, some excesses are there in the airlines department also. They can.
Tell us, madam.
But
You see, we have been
authentication is
keeping this
required
matter-
from the
we have been-
IG, DIG and
We have
everything.
been keeping this matter before us from 1612,
Yes, Your Lordship.
1812,
Yes.
28106,
Last occasion, I have given
5206
the
and
notification and everything on the last.
18/5 is the time, is the date when we said heard in part. We are supposed to release it. On request, we are taking it up.
Meanwhile, the advocates have changed and they have filed additional affidavit.
We have
also.
not allowed them to take any additional plea. Trust us. You can go through the video, not one additional plea. Not one sentence outside the.
These are the matter of record, and my humble submission is that looking to the scenario. and
Article
situation,
21.
And this is one
Right
of
to
the,
life. I cannot delay it further.
but looking to this situation, that is why Government of India has taken a step and all the matters are being transferred to Gauhati High Court.
Arguments without hitting the facts of the case, without changing anything in the facts of the case, madam, difficult for us to appreciate.
Because the reason being the situation looking to that, every procedure could not be able to be followed. That is
Admit
the,
it.
maybe if there is
Admit
any,
it. Why manipulate it?
there is as such no manipulation, Your Lordship.
7th arrest, 8th arrest.
That is given in the notification, but some.
So the state
Hesitation
government had a
was-
prenomination that he would be arrested and he was taken into custody,
CBI.
placed in the airport for the investigating authority to pick him up.
No.
Can that be the story? There can be only one story. He was arrested by the investigating authority.
The moment he has come in the custody of the CBI.
When? That is what we are
It
asking.
is on 8th, that they have produced him before the magistrate.
They do not put the time of arrest. Have you seen the arrest memo?
That, Lord, with all my respect, they have put
Kindly see the arrest memo.
9:40 AM. In the, at least they have
Where?
mentioned that.
Where? To us? Why did we miss it on the last occasion?
At least they have put 9:40 AM.
Where is it?
It was there, I have also gone to the ground of arrest is there.
Now, if the date of,
Page
if the
number
time of
9.
arrest is there, we may be wrong.
107, page number 107.
10?
Page 107. Page 107 of my petition. That in time, 9:40 AM.
Yeah. Date and time of personal search
Lord.
is 9:40.
Personal search memo 9:40.
What is page 99?
And 99 is, at time of arrest is 9:20 AM.
And where is your WhatsApp part?
WhatsApp part on the last occasion, I have given Your Lordship one bunch. Along with
Kindly
the
give,
notification. It was in the record
Looks-
and the time is reflecting there. I have given on the.
Bunch. এই পাৰ্ট হাৰ্ডৰ এইটোত কি কয়? এমাহত ৰিলিজ কৰি দিব লাগে নেকি? পাৰ্ট হাৰ্ডটো এমাহত ৰিলিজ কৰি দিব লাগে নেকি? নটিফিকেশ্যন এখন আছে নে?
Months this. সৰু এটা বাঞ্চ আছে 4-5 pages.
What do you say to that lease line and the double tick?
My lord, I have not.
You
seen that.
received it?
I have not seen that.
Huh?
I have not gone through that also, that double
That would
click.
go very against you.
That
If there's
double,
a double tick, the delivery is there.
no, my lord, my humble submission, when that double click was there, when the screenshot was taken,
You
The-
said it did
I
not
have-
receive it. It could not have been received.
no.
When the base goes,
No, my humble submission is,
hmm,
I have one copy. That one.
my lord, the
just
double click,
a minute, just a minute.
Spice.
Hmm.
the double click, 8 June
No,
2020,
any queries?
my lord, 8 June 2025, it clearly shows 3:25 PM. 3:25 PM.
He was produced at what time?
It says 4:30,
4:30.
2 hours.
2 hours. 2 hours.
What to do? Time has been given by the apex court.
But that judgment has come later on, so
Then,
it will run
then-
prospectively.
no,
2
if-
hours judgment, Mihir
no,
Sah's case.
2 hours, 2 hours prospectively before the year, my lord, even the time frame was not there. The time frame came because of the sensitivity of the nature that at least 2 hours before he is produced, that has to be given.
So now when you know that the person is in Manipur and 1 hour before production, you are giving him that, okay. In that case, the WhatsApp must have been sent from Gauhati, not from Imphal.
No, he has given number from Imphal also. They have called over phone. They have called over phone.
And why not someone from the airport? No one in the airport, no officer in the airport was available. No responsible person in the airport was available to.
Everybody denied.
My lord,
To his statement.
Including the,
Yes, they have called. We have given the statement also to that effect. They have denied.
whose statement?
No, not their statement. IO has, while giving the reply, he said that they have denied in our parawise reply.
my lord, my lord, on the last occasion, your lordship was pleased to ask a very pertinent question. In the airport, CIS officials are there, Manipur police personnel are there, other government authorities are there, the flight officials are there. So one could have signed as a witness.
One could have is not the issue. Was one approached? If people refuse, they can't help it.
No, but
But if they have been approached in other arrest warrants or in other things, we have seen
my lord,
that the Gaubura was approached. So and so person was standing there, he was approached, he refused.
yes,
So I signed.
mm,
And here it is simply no one wanted to sign.
general, a very general
He
statement.
is the commander of that organization. Everybody knows his activities. And we have given to that effect reply parawise in our objection 255 page. Lord.
And now another thing, this doc scanner, this page 10 that you have seen, Lisa Asen. The WhatsApp is to Lisa Asen, the
Yes.
daughter.
Daughter.
You said you sent it to someone else also.
Yes, his friend also.
Where is that?
We have given a statement here, Your Lordship.
That WhatsApp would be there.
Like,
This kind of a thing would be there. Not sent to the friend by WhatsApp. Friend only called up.
Friend only called up. Here it is submitted that the applicant himself provided the mobile number
Of?
belong to his wife, Bimoli Devi. It is as 255 hour paragraph in objection.
What
Bimoli Devi.
was the flight time?
Flight time,
When did you reach this thing?
maybe 1 o'clock or 12 o'clock.
What is the usual flight times from there?
Normally 9:50.
9:50 there is one flight.
9:50, normally 9:50. Then there's another flight one, about 2, 3 flights are operating, but it starts during those days. It starts from 9. It is 9:15. First Indigo flight is the 9:15. Then sometimes they change on the particular day that I.
That is what we would like to know, madam. Give us that particular details. And the airport, 9:40 you arrested. Which was the flight taken? And the what time were the tickets arranged? All the emergency flight numbers, emergency tickets, we don't doubt that for a moment. The date of the time of booking of the tickets and the time of the flight. No doubt they have flown that day because they have produced him here. They have produced him here, so no doubt they have flown on that day. What was the flight? Because this is given at 3:25 that WhatsApp received. Is it not?
This is, I have already given, searching in the. This is.
Which one?
To
whom? To whom?
Sir, on the last occasion during the.
To
course of-
whom was it given?
Sir, Lordship has seen.
Daughter one we have here.
And this is not, this mobile number is not in the name of the daughter, but in. Well, if I said.
What is his name? Kindly have Central Bureau of Investigation, page 5.
Yes, page.
This is your document.
Yes, page 5. This is the
Kindly have the fourth
press
paragraph.
clipping, press clip.
It is you have given it. Is it given by you?
Yes, Your Lordship.
Page, the fifth page, fifth paragraph.
Yes.
It may be mentioned.
It may be mentioned here that the situation in Manipur escalated yesterday.
We stop here for a moment. You say it escalated. Now the CBI is saying so, not the state government.
Not the state government.
Now go ahead.
This is a press
Go
report.
go ahead. Late evening after word of Kannan Singh.
Kannan Singh. And four
Entire
others
story
being
that
picked up by the
you got
police.
information
red
that
light,
you were
white.
there in the airport and therefore you reached the airport and you suddenly picked him up. Falsified by your press release.
This is a press clip.
Clipping at top of it, what is written? Central Bureau of.
Yes, press clipping. In the next page also, it is clear that the CBI statement made it clear that the Singh was arrested from the Imphal airport on Sunday.
Then how can there be Kannan Singh being taken into custody? So now you're trying to draw a difference between custody
No.
and arrest. I'm not even on that. The thing is, admitted press release says, yesterday, after taking into custody of Kannan Singh, evening everything erupted. Is it not? That contradicts the story that we arrested him on Sunday at the airport because we had specific information.
Yeah.
Please look into it again. I'm not required to go through all these things so minutely while considering a bail petition. Is it not? But why are we doing this? We know the efforts put in by the agency. We do know that. We also know that a person, whether involved or not, prima facie, would have a right to 22(1). And we also have to see, that is the whole thing. From the youth we have all heard, from the time we could understand, the authorities doing the arrest, the police, the investigating authority, the judiciary, the prosecuting team, always at a disadvantage because we have to be within the boundaries of law. Everybody else can be outside the boundaries. Is it not?
But
The difficulty is there.
he was involved there. He was terminated from the police
We
department
understand
also.
everything. He was terminated prior, not after the incident.
Prior. So his involvement
has an
is there.
history.
His involvement is there.
Our first opening thing was he may be a person who is required to face the trial. We are not on that. We cannot be on that. What we can now see is your press release and the arrest memo,
That is
not
true,
matching.
But in the serious offenses, even the Supreme Court in cut-off cases made an observation that slight defect in the procedural defect.
Is it slight? Is it
some
slight?
deviation. Looking to the situation, nobody could move
We
anywhere.
arrested
We
him.
have to
We arrested him.
bring him.
We arrested him on Saturday. There was chaos. We could not do anything about it. Somehow we made the ticket. We reached the airport. We reached the Gauhati. Was the correct story. Try to find out a different story. This is your clipping.
Yes, this is the matter of.
This
record which
is not a page given to me by.
No, these are the matter of record in the sense that day on the time of hearing, whatever queries are there, I have given to the in IO and he has given me all this.
We appreciate it so much, the cooperation. We appreciate it so much. We really appreciate it. And that is why on a Saturday, even though you had a bad throat, we thought we could take up the matter, finish it off, because we would have the cooperation. We would have an honest cooperation. Not only a rebuttal of what has been said, but we wanted an honest cooperation. Our voice may at times be modulated because that is the way we have been speaking throughout our entire career. It does not reflect what we are feeling inside. Sometimes our voice goes up, we are reminded this may not be working. It is not on that. What we are trying to see is, can the arrest be upheld, to be not vitiated on the face of the things on record? It is the only thing. Every case Supreme Court has said guilt or otherwise is the second part. We are not to go into that unless something very obvious is there before us. In this particular case, you would like to have another after some time to have a clarification of what we have asked. Anyway, we have to wait for your tickets, the time of the booking. Now, if it comes up on a Saturday, without commenting on what had happened, what might have happened, the only thing would be the reflections in the memo arrest do not tally with the records available. That being so, the grounds of arrest communicated in the manner in which has been done does not satisfy the court. That he had proper opportunity to defend himself when taken up for remand. So the continued custody goes. Supreme Court has also said that once the continued custody goes, there is no bar in taking into custody again properly. We are not stopping you.
But there is every likelihood that he may abscond because it took so long time to apprehend.
The requirement on our part would be to give conditions where we feel would be enough for him not to go out of the territorial jurisdiction of either the investigating authority or of the court. That is what bail is. There is every possibility of every man who has got a prima facie case against him, a POCSO person. 100% chance he is going to abscond. Bails are granted when there is a violation. These kind of acts, heinous murders, at one point of time the bail comes into play. So whether he could abscond or not cannot be a ground to deny him bail. In Pamidi Anand, we have laid down conditions ensuring that he would be within the jurisdiction. He would not be out of jurisdiction. So there is a chance that he would escape is one part of it, which we will keep into consideration. But if the memo of arrest varies with the facts, then
That has
it
to
is
be
not
done.
that there was a deliberate attempt on somebody. No, we are not commenting on that for a minute. We are saying that he might not have had the opportunity to resist the remand
See.
when required, and therefore the continued custody goes.
But during the time of production, the
Ah.
magistrate has clearly asked him
Hmm.
with regard to this grounds of arrest. He said, yes, I know. And
Hmm.
my
He
learning friend
knows.
has annexed the order also.
He
of
knows.
The
Did
magistrate.
the
He has two mobile phone
did the
also.
magistrate ask him, you know it, could you take steps, sir? Has your family taken steps, sir? Was it enough for you to, do you want to contest that ground of arrest? No. Do you have a piece of paper saying grounds of arrest? Yes, sir, I do. Admission of fact may not be admission of guilt.
But in the order of 8/6/25, time is given 4:30.
When he was produced,
He was
then
produced
again it
and the
goes
court.
against you. Then it again goes against you. We'll tell you why. The more we go deep into this, the more trouble you are in. Where is that WhatsApp part?
3:20 PM.
No. That small pieces of paper you had given. What page was it? 1 to
Yes.
12? Can you show me that 1 to 12?
3:25 PM.
That is what? Can you read at the top? It is the memorandum of arrest. Is it? There are 3 messages. Hello, document, and document. Is it? Now kindly show us what is the first one. Hello is received at what? 3:25.
One memorandum of arrest photocopy
At
is also given.
3:25.
3:25.
Kindly see grounds of arrest at what time? 4:19. You are producing him at 4:30. 10 minutes. Even if you don't go by 2 hours, is 10 minutes enough?
At that point of time, 2 hours, say that this has.
I'm
come to
not
us.
going by 2 hours. I would just evaluate whether 10 minutes was enough.
But prior to that, he has been in from airport. His family member was informed, his friend was informed. We have
Without
given
the written
reply.
ground of arrest, the first time the written ground of arrest goes is at 4:19. Verbal communication of the fact of arrest and recitation of the grounds of arrest has been held not to be enough prior to his arrest in different cases. The time of 2 hours has come later on, but the grounds of arrest in written has to be given.
Was-
That has come before. Now we evaluate whether 10 minutes was a.
But to that effect, we have given an explanation to our reply 255, page number 255.
Hmm.
It is a part of 20, paragraph number 20B,
Ah,
A and B.
ah.
A is submitted that applicant himself provided the mobile number of his daughter, namely Lija Hassan, and accordingly the memorandum of arrest and ground of arrest was
Now,
shared on the mobile
now,
number.
if we go by the arresting officer's version and the CBI version, he being taken into custody on 7th, and the investigating officer saying, we were informed of his presence at the airport only on 8th morning, where we rushed. Would these two not contradict? They would contradict somewhere.
Somewhere contradiction is there.
That
but
is where the problem is.
The ground reality is quite different. It is there, but the ground reality.
What
we
was
have
it?
To see the ground
What was it?
reality also looking to the.
What was it creates the doubt. Since no one is coming up with the right picture, you are the person who could have given, when I say you, it is the CBI or the defending authority. They were the right persons to have said so. True, on 7th. True, memorandum of arrest is on 9th, 8th, 9:40, true, because till that point of time, we were not arresting him. We were taking him safely to the airport. We were taking him safely to the airport so that there is no further disturbance. That is not what the person says. He says, I heard he's there, I rushed. I caught him.
But
Then
it is
he
there
has
for the
changed.
Airport
Even
is
if he-
having a very vast area.
So 7th, he must be inside
And
the airport.
inside, no one go without security check. So he might be arrested from the outside.
Then the story of on the memo of arrest or the affidavit goes. When one sentence goes, can we believe the rest of it? which is consequential to that sentence.
Sequential, but going to inside, security check is required.
So
Huh.
if this man
Before
has
that,
entered,
or the precinct is known as the
if
airport.
the
area.
investigating authority entered the airport, it had to be with the permission of the
Yes,
CISF
of the- Yes.
or,
Definitely they had
or
the
with a
permission.
boarding pass. Tickets made before the arrest.
No, they had a permission. Probably they will have a permission
To do what?
to go inside the
Ah.
air.
So if they went with the permission, a man permitted them to enter an arrest, would he not sign that the arrest is complete? We find the difficulty in the court. We are not standing here as
Into the seriousness and
Oh,
defect in the
not
procedure.
perhaps with
If we'll measure,
no comments on the requirement of such a person being behind bars or otherwise in custody while the investigation is on. No comments from our side at this stage. At this stage, no comments. But when the question of the legality of the arrest and the continued custody after that is an issue, that part we have to evaluate only to see how much we can trust our instincts to say it was correct. If not, the Supreme Court is conscious and says can be done correctly again.
but to
I
that
think
effect, since-
Mihir Rajesh sir says so.
Yes,
It can be done again.
yes, Mihir Rajesh.
Then why defend it in a manner which is not coming up on records? And if you can show us the records, then the ball would go to his court. And it would be a spinning ball, a twisting ball, and a long arm ball, and he'll have to. Bail is the rule.
But in case of 43D,
Huh?
that is of UAPA Act, 43 Arms
We are
Act is
talking,
also
we are
there.
talking of the Pamidi. In Pamidi, we are talking of the conditions being laid down. Only the condition part. We are not on the why the bail can be granted under what condition, but the condition part
Condition. Yes.
to ensure that he is available. The best that the law can do without taking him into custody.
But to that
An
effect,
invisible
the
wall.
seriousness, Vatali principle is also there. If the Vatali principle is based on all these serious offenses,
Yes.
and Vatali is the name where from it has come,
Mm.
that principle. So wherein it is clearly said is, if the court is not this with regard to the court satisfaction, then we will have to see his flight risk. If one is not satisfied, other is flight risk.
Mm.
If prima
Now
facie
that
is not
flight
satisfied,
risk will be to
flight
the
risk is also
flight
very
risk
important.
will be, see, even when a bail bond, when we give a certain condition, one of the condition always remains any other condition that the authority, the court below, the trial court may like to impose, looking at the facts and circumstances. And it is not only a bail petition which can be objected, even a bail bond can be objected. It is not enough, sir. He has more than this. He can afford this to run away, is it not? You would have all the opportunities to do so. But can we not, are we not required to go by the law?
That is true, but
We cannot step out of it.
that has been also dealt in this case, Your Lordship, in NIA.
We will take up,
Jahur
we will,
Ahmad
we will,
Sahas
we will,
Vatali.
we will take up that part of the law along with your instructions on the date of the booking of the tickets, the manner in which the airport was entered into. And this is only to see whether the fact that he was arrested on 7th or he was arrested on 8th.
This explanation, the gap
This-
has to
that-
be filled.
If that gap is filled up,
Filled up.
the arrest 9:50, immediately 10 o'clock you're making a ticket for the 1 o'clock flight. To some extent, we believe that the arrest, is it? Tickets booked at 8 o'clock on the 8th. You could not presume an arrest. It was only an information. And then you have to explain the CBI part saying that yesterday, because of his arrest, there was chaos. So that it may be so that the arresting authority, not being very conversant with the terms used in courts, taken into custody, not arrested, and shown arrested at a particular point of time when we are
Particular
required to do.
point
So
of
that
time,
is what
yeah.
happened in Pamidi's case also, if I'm not wrong. Taken into custody at a particular point of time and then arrested in the police station.
Listed on the letter.
But the arrest per law starts the moment you tell him don't move. The arrest starts. 24 starts from there, not from the time you sign the document. So therefore, we are trying to find out whether it is 7th or whether it is 8th. Not to bring any aspiration on the investigating officer or the arresting authority. Let us be.
As of now, barring the notification, nowhere it is shown that he is arrested on 7. It is shown as 8.
Naturally.
And notification is there, that barring notification.
Naturally, once the statement comes that we arrested him in the airport, that is what is going to follow. What happened prior to that cannot be changed. Let us know that. If the CBI says that no, that Kanan Singh was wrongly inserted in the notification, it was 4 other people.
Okay.
It was wrongly inserted because of our excitement to give that press release. Our press person made a mistake. And we were concentrating there, we did not notice that. I don't know. But we speak our mind openly in the court so that we know what we are dealing with.
These things are dealt with here in the 14(3)(d). So tripod test is also required to be seen apart from the prima facie. Well, that is the Vatali's principle wherein it is dealt with.
To do what?
The prima facie and the tripod test is flight risk. So this judgment, popular judgment is there. These are being taught in the colleges and schools also.
Flight risk is something which can be contained.
But all said and done, there is no as such watertight compartment. Even in number of conditions are imposed. Sometimes we have seen there is a.
This is without anything on our with our opinion. But there have been instances where entire jails have been broken through and people have been taken out. Can you say that a jail would be enough to hold back a man? We have seen it here, near us, where jails have been broken and people have been brought out.
Then where is the authority?
What consequence is another thing, but even jails are not enough to hold people.
Yes. Nowhere watertight compartment.
So watertight? So we'll have a few holes here and there and try and contain him.
And the recent judgment is of Umar Khalid, which I have brought the summation. It is a very big judgment. So somehow I got the summation.
We have seen those documents. We have seen those documents.
All these things.
When on several occasions he has placed it before us. It is God's grace that we do not remember where we have seen it, but by God's grace we remember we have seen it.
During the course
It
of.
takes a glance and we remember, yes, ye padha hai, pehle padha hai.
The number of cases are there, so it may be some.
If this is a part of record, have it at 2.
Today.
Today. Because it's a matter of Article 21. I cannot keep it in any longer. And if I keep it any longer.
One matter is.
I understand.
Hanging there in the 20.
I understand. If you can have
they
the
have come to call me.
Please go. That is why we said at 2. Start there.
Let me see.
Start there. You are not in a hurry to leave today, sir. He is not in a hurry. And we cannot be. We cannot be in a hurry. So.
Authorized, my lord.
Yes. Happened.
Lordship, just on last occasion, asked me to come with your lordship judgment that I am. That on second notice, lordship. That your lordship heard on the Wednesday, lordship.
Would the relief granted there?
Relief is set aside and.
No, the proceedings from the stage of the second show cause notice is set aside.
Here your lordship is, but on marriage also I have a good case.
Please tell us, please show us that part also.
Lordship. Lordship, the whole case started from a complaint lodged by one Habijul Haq. That complaint is not a part of the listed documents. Ought to have been. And though his name as a witness, he was never brought. And the witness in the charge sheet differed from the witness examined. Lordship may kindly see the
So there was
listed
no
witness.
notice of those witnesses being examined.
And
You
three of
did
the
not have
witnesses not
anything.
examined before me.
So what are you depending upon, any citation?
Lordship, yes, Lordship.
That the witness has to be made known to you.
One is on defense assistant that I'll be relying on Justice
Did you
Ujjal's
ask for
judgment.
one?
Lordship,
Did you ask for one?
I didn't ask for, but I have to be intimated. I have to tell that I'm a constable,
He's
Lordship.
smart enough to know
Lordship, I'm
the law for a
constable.
demand.
I'm only a constable, Lordship. That ought to have been. And the
Defense
other,
assistant is something we'll deal with.
and
on a
on
lighter
the
way.
point of Lordship, on the definite finding that charge was that initial complaint was filed by the Hibjul was that one Mukund Upadhyay was the SI and one Lordship Deka.
Where
His
is
name is
that
Hirak Jyoti
the-
Deka. These
it-
2% demanded money. He met
This-
these 2%.
Disciplinary proceeding show cause notice is here somewhere.
Lordship,
Disciplinary, first show cause.
first Lordship, may kindly see the intimation sent to the superintendent of police by the arresting authority, that is page 22.
So tell me one thing, the witness has to be examined in, you have to be intimated about the witnesses
Witnesses.
and they have to be examined in your presence with an opportunity of cross-examination. That is your, one of the grounds.
And last,
Now, that you were never intimated about the witnesses,
Those
where
are-
does it come in? What is the law, in any case law on that?
Lordship. Now, Lordship, here is a case, Lordship, in which the complainant was not examined.
That
So
is,
is the name that I'll be relying on, Lordship.
that you have said.
1999 2SCC page 10.
Witnesses who are required to be examined has to be informed to you, if I'm not wrong.
Is
have you-
that because
If
the
you have an assistant counsel, you just try to find out Hari Mohan versus Union of India.
Hari Mohan versus Union of India. Lordship, in this case, Kuldeep Singh's case, Supreme Court says that on whose basis the all this started ought to have been examined. Here is the same case. It is the Habijul Hawk who lost the complaint that demand was money by Mukunda Upadhyay and Lordship Jyoti Prakash, this Hirak Jyoti Deka. Now, this Habijul has not been examined, though his name in the charge sheet. And his allegations, the money was demanded by Upadhyay and Deka, not me. His own statement is that allegation that I was called by the SI, told him that he will give something, go outside and take it, take a packet. And that is my only, Lordship, fault, Lordship.
What happened to the criminal case?
That is not yet, only charge sheet has been filed.
The witnesses will be the same.
Not, maybe the same. So on merit, I have a good case, Lordship. Lordship, can you see the depositions? Who put the questions that cross-examination is not clear. And all the witness had been pushed the same question and same answer. Even the line by line, Lordship, word by word, are the same.
Just a minute, illegal gratification from the complainant. Was he arrested along with the money and all?
They told me that money was recovered from my room. But the lady has been trapped on the same day. I was accosted outside. How can money goes to my room? Their own statement. That's why I tried to run. They got hold of me and took me to my room.
When the others were being paid?
No, the money has been recovered from Mukunda's room also.
They did not trap you accepting the money.
I thought something fishy. I tried to run away. That is my explanation, Lordship. And it is their own case that I didn't demand the money. Money demanded by this Mukunda Upadhyay and Hirak Jyoti Deka. Hirak Jyoti,
demanded 60, and when he goes to Mukunda told it 1 lakh. Lordship, the ground of arrest will,
No, what is that statement of allegation?
Lordship,
What did you do? Which is the misconduct?
Lordship, statement of allegation, Lordship will find. First Soko's notice,
Forget,
page
kindly
32, page 32.
kindly for a moment, forget what your client has told you. Forget everything.
Lordship,
Now tell me what is the misconduct as per the statement of allegations.
that I demanded money,
Where
Lordship,
was that?
while he was statement of allegation, page 32.
I'm reading that, please.
While he was posted at Laharigarh PS Morigao district, he was arrested by a team of vigilance, anti-corruption, Assam, so and so, in a trap case of being a part of criminal conspiracy. With SIP Mukunda Upadhyay and Hirokjyoti Deka of Laharigarh demanding illegal gratification from the complainant.
Oh, just a minute. When?
Date has not been mentioned.
Is specific.
Has to be specific.
Is it?
Lordship,
You do not know forget what you heard about from the client. Do you know what has happened?
Lordship.
You are involved in a conspiracy. How? Who asked the money? He asked the money. You said you can keep it in my home. That has to be specific.
Lordship.
Charges.
Lordship. Even the charges fails through, Lordship.
And then the inquiry carried out so far revealed that there is sufficient material to show. So there is already an inquiry going on.
And Lordship, my bail order will speak out because it was, I was granted bail perusing the CD. That will speak page 28, Lordship. Second paragraph, Lordship. From the AJR filed by the informant Habijul Haq, it appears that on 14/7/23, there is a dispute between the family and so and so. One Kajimuddin filed. In that case, police arrested the informant and sent him to jail. On 9/8/23, after getting bail, he visited Lahorigarh police station to know about the bail of his other family members and met one police personnel, Hirokjyoti Deka, who told him that one Dildar Hussain required to be produced and for bail of other accused person, demanding 5,000 each, in total 60,000. On that day, the informant met the investigating officer Mukunda Upadhyay, who increased the bribe money to 1 lakh. And at that time, police personnel Hirokjyoti Deka was also present. The informant was not interested to pay the demand bribe money and recorded the conversation between him. Even he recorded it in a device, Lordship, electronic device. And Mukunda Upadhyay and Hirokjyoti Deka in recording device. Thereafter, the informant filed a written AJR and vigilance and anti-corruption Assam with a prayer to take action. The Vigilant and Anti-Corruption Assam, after verifying the facts, registered case and initiated trap proceeding and was able to apprehend the accused with 2 others, while the accused Mizanul Haq accepted tainted bribe money amounting from the informant for the other accused persons. So those two are all, I just became a victim, Lordship, being a subordinate officer.
From you were the post office.
Lordship. And even the ground of arrest also speaks the same, Lordship.
You see, it does not even say that you had accepted that money on behalf of the other persons. So what could he have resisted? Which part of the fact he could have resisted or allegation he could have resisted? Where are the statements?
Lordship, may come to page 39, Lordship. The second last paragraph, page 39. This statement of PW1. After some time, Start with after some time. After some time, the
He
complainant
has handed over the demanded bribe. Who took it?
handed over part of the demanded bribe.
Wait.
Second last paragraph, after
Just a
some time,
minute.
Lordship.
Paragraph one more paragraph before that, all the complaint.
Yes, Lord. After some time, the
When
complainant
when
gave
it's at
the
the police
prefix
station at
signal
about 8:20,
indicating
we reached to the
that
computer.
he has handed over part of the demanded bribe. Accordingly, we rushed into the computer room of the police station and found SIP Mukundo Upadhyay and Constable Hirok Jyoti Deka were present. The complainant informed us that SI Mukundo Upadhyay called one police personnel over phone and directed him to come to his room. Accordingly, one police personnel, Mizanul Haq, came to SI Mukundo Upadhyay's room and was instructed by SI Mukundo Upadhyay. The complainant handed over part of the demand bribe money to Mizanul Haq. Lordship, where is my role, Lordship? On demanding and being a part of a criminal conspiracy.
And what is your explanation why the money was found in your room?
No, Lordship, my
There must have been
explanation.
some explanation.
My explanation, Lordship. Page 63, Lordship.
Page 40. Nikhil Das.
Question answers cross.
In cross-examination, charged person was asked. Madam, this is a statement given by whom?
Page. Lordship,
Yeah,
is,
just a minute. Just
Lordship
a minute. This is a statement of Muzaffar Hussain. And who is being cross-examined?
that is not clear, Lordship.
It is clear.
In cross-examination, the charged person, so and so.
Was asked. Who was asked the question? Accused is being asked questions
Yes,
in the
Lord.
cross-examination.
By the inquiry officer. By the inquiry officer.
Bribe money was recovered from you. What do you have to say? Give me 2 minutes. The medicine. Madam, the cross-examination of the accused has been done.
By the inquiry officer.
When the statement of the PW number 1 is being recorded.
Also.
Is it not? The entire inquiry goes. We will not go into the charges or anything.
But before that, there was inquiry also, Lordship. That also we need to get hold of, Lordship, of 11/8/2023.
What happened in that?
Just, I don't know, Lordship. We have to go through.
Against the
record,
same
Lordship.
person?
No. 11/8/2023. Thereafter, Shokos was issued.
So that's a preliminary inquiry. We don't need to know
Preliminary
that. Why should we?
But Rule 16(3) has to be considered in the light of the provision contained that.
None.
Yeah. 311(2), Lordship. The Constitution to find out whether its purpose to provide.
We will not go so deep into it.
Lordship.
Although we would like to go into every aspect of the matter and find out everything.
Lordship.
We will not go so deep into it. The delinquent being cross-examined when the witnesses of the when the evidence of the witnesses for the discipline authority was being taken, that itself vitiates the
Proceeding.
inquiry proceedings itself. So the inquiry at that point of time goes. Although there may be other arguments that you have, we'll record that. That although there may be many other arguments that you may have, we need not go into this when the
Lordship.
inquiry fails at that stage.
Lordship.
The charge sheet we find is not specific enough for you to deal with when the date, time, and the manner of your involvement in whatsoever has not been made known to you. Before in the bail petition, that the money was found in your room and everything is there. But in the charge sheet itself, which was served to you for the disciplinary proceeding, that part is not there. Part of the money was recovered from you. And therefore, you could have answered it in any manner you would have liked to, but you did not have the opportunity to do so. Therefore, the show cause notice itself was insufficient for you to answer.
Lordship.
When the show cause notice goes and the proceedings taken up goes,
Lordship.
therefore the entire proceedings goes. However, looking at the nature of the allegations which you are facing,
Liberty.
the criminal proceeding,
Liberty.
there would be a liberty for them to proceed. The time period for which you have been kept out of service on the basis of a wrong disciplinary proceeding would be treated to be as under suspension. your continuity in suspension after you report to the disciplinary authority on a particular date. The requirement of keeping you under suspension because of the allegations of PC, the cases are in case that either post you somewhere else or keep you under suspension because there is an allegation of corruption against you. That we will leave it open to them. They will take a call.
And I'll be reinstated back.
Yes, but under suspension, the decision to keep you under suspension after your reinstatement would lie upon them whether they want to have you posted in some other office or to keep you under continuous suspension in that office for a particular period of time, which needs to be reviewed again in 90 days.
Lordship.
The continuity.
Lordship.
Can you get me a printout of the KC Sareen case? KCSAREE and KC Sareen. If I'm not wrong, Kailash Chand Sareen.
Yes, is Sarini.
KC Sareen, if you can get me, that deals with what to do. It actually deals with what to do for not setting aside the conviction. The sentence requires to be stayed, not the conviction part of it. But there it says why I would give them the liberty to keep you under suspension or not. KC Sareen, if you can get it. Yes, no. Yes, no.
Lordship, that in that case, Lordship, I just have to go through because these are all the extracts. The statements are most probably in the vernacular, Lordship, and these are the extracts.
No.
No.
Yes,
Sorry.
Lordship. Yes.
Not translated.
Lordship, may kindly peruse.
Where is the extra?
These are
Findings
because
of the
these all
Department of
these are
Justice.
that means these are all part of the inquiry report, Lordship. These things, Lordship. That's why I'm just telling you, Lordship. If
Huh?
this can be taken up on I think Tuesday also, Lordship, I
Do we
don't
have
have
the
any
time to
problem.
dictate?
Yes, Lordship.
Do we have the time to dictate?
Most probably this is with it because today, Lordship, actually I'm not feeling well, Lordship. That's why the problem. I just, Lordship may pass, but for this is my humble prayer, Lordship. Lordship may take, or even on Monday also. I'll just go through this only, Lordship. The
You
file.
have the records. with you?
Records most probably is in the court, Lordship. Sorry, in the office, Lordship. Yes, record is there, Lordship.
Pass us the record.
Record receipt, Lordship.
We'll accommodate you.
Lordship. No, record here I'm not having right now. That's the problem, Lordship. Otherwise, I could have gone through. It is in the office, but today I am crippled, Lordship. No one is here, Lordship. Most of the cases, these are seen, Lordship. The translation part is here, and most of the cases, Lordship, and record is something in the vernacular, Lordship. Most of the cases that we
I'll
have seen.
just point out one thing, madam. We'll accommodate you because you made a request. No, is on that, but kindly have an extra G for a moment.
An exact G. Yes, Lordship.
You find the superintendent
Second
of,
course.
the superintendent of police signature is there? Now,
Yes.
Fido? So this is not a
Not
translated copy.
misconduct,
It is
indiscipline
not a,
act.
no, it is not a vernacular translation from the.
No, no,
vernacular.
definitely.
Now, the next page is the findings of the departmental procedure.
Yes, these are the
Now
findings.
this is, now we'll just see one more thing.
These are not what I am
Just a minute.
telling, Lordship. These
Page 56.
page 56.
It contains the signature of the inquiry
Additional
officer.
FP. So it's not a translated
Uh-huh.
copy.
It is just a signed copy. Is it not?
Signed copy.
Now the inquiry officer in the record before this court
Yes, Lordship.
is findings of the inquiry officer.
Yes, Lordship.
This is a part of page 40,
Yes.
which cannot be in vernacular. And he records, the inquiry officer says, in cross-examination, the charged person was asked. Now I take it to be a.
Yes, Lordship.
a
That's why,
misstatement.
Lordship, I just want to
But
see
then
that
again, he
record,
says,
Lordship.
money
This is-
was kept and I took it to my quarter. So again, it is it is actually a cross-examination of the charged person.
Lordship.
That
That's why,
it
Lordship,
goes.
I just want to go through the record, Lordship. Actually, no one, my colleagues are here, Lordship, just to get the record, and this is the main thing, Lordship.
There are times when you need a date. Heard Mr. B. Chakraborty, learned counsel, appearing for the petitioner, also heard. Appearing, learned additional senior government advocate. The matter. Rule was issued on 23/1/2025. Matter has been heard at length. Step. On a perusal of the writ petition and a consideration of the submissions made by the learned counsel appearing for the petitioner, it appears to this court that the charge memorandum of charge served upon the petitioner herein contains the charges to the extent that he had exhibited moral turpitude and failed to uphold integrity and abused powers, being a police personnel in a discipline forced, full stop. The allegation is that he was involved in a criminal conspiracy with two other persons of demanding illegal gratification from the complainant, who had lodged an FIR before the Vigilance and Anti-Corruption Police Station, which came to be recorded as a CBPS case number 60 of 2023 under section 120 within bracket B IPC read with section 7 within bracket A of the PC Act 1988 in a trap case, full stop. On going through the charges and the statement of allegations, we find that this court notices that the same does not reflect the manner in which the petitioner was suspected to have been involved in a criminal conspiracy, in as much as the details of the date of the alleged incident and the details of his alleged participation in demanding and accepting illegal gratification were not made known to him. The second show cause notice, which is annexed to the writ petition and has not yet been disputed by the respondent authorities in their affidavit position, contains a recording that on a perusal of the findings of the inquiry officer, the charges of gross misconduct, indiscipline act, and dereliction of duty were determined to have been proved, and hence the delinquent official was liable for punishment. On going through the inquiry report, this court notices that while recording the statements of the different PWs, at the end of their statement, the delinquent constable had been cross-examined on the basis of statements made by the prosecution witnesses. There is no indication in the report of the inquiry officer that the petitioner had been given the opportunity to cross-examine the prosecution witness, and that he had denied such an to avail such an opportunity, and had requested for himself to be cross-examined after each of the prosecution witnesses were examined, full stop. Ms. Bhattacharya, learned additional government advocate, has submitted that the records are not with her, although it may be available in the office of the government advocate, and she would like an opportunity to go through the same to find out whether the documents given with the writ petition, which have not been denied in the affidavit in opposition, are the correct versions of the records contained in the file of the disciplinary proceeding, full stop. The learned counsel for the petitioner has also placed before this court two judgments, one being the judgment passed in WPC 799 of 2017, and the other being Kuldeep Singh versus Commissioner of Police and others, reported as 1999 to SCC 10.
And also Lordship 20, that's Babul Hussain, his Lordship has
The
referred
learned
to.
counsel for the petitioner has submitted that he would place some more citations before this court, full stop, affording opportunity to both the learned counsel for the petitioner and the additional senior government advocate to further address this court. Stop. Comma. List this matter again on. Ten.
11.
11.
12,
11, 12, anything.
12 Lordship.
10th.
10.
10 Lordship.
10. Being Lordship, there are many fixed matters. Lordship.
11 matters are fixed.
She has to produce the records only, Lordship.
Yeah, records are
11
available.
matters are fixed.
Yeah.
And or 9th.
9th on Monday. Okay, Lordship.
Or you need some more date, then it will be 12th. 12th.
12 will be
12 is fine with you, sir.
12.
Lordship.
12th of
February.
February 2026. The learned counsels are requested to conclude their arguments on the effort.
Lordship.
The part had, it will be
Yes, Lordship. No
Conclude
issue.
their arguments. Part heard is a very dangerous word.
Lordship.
The
If
first
you-
question is why heard it in part?
Lordship.
What did not complete? Did we not understand?
That of course is Lordship.
No, pertinent question.
Oblige.
Yes, sir.
I had very little time to go through the petition, Lordship. But still I am thinking, what is the reason petitioner is claiming salary from 2009?
And
Whereas
the
her
only
ser-
reason is at page 80. That is the date on when the post on which she was regularized fell vacant. And therefore, when some regularized to
If
that post,
that is the reason, Lordship, then it's a settled case. She cannot claim, I cannot claim benefit from the date of falling the post vacant. Or I become eligible to be promoted to that post. That is a settled law,
Hmm.
Lordship.
that is why we needed your assistance.
One reason I found, Lordship,
Hmm.
that too in the synopsis.
Please.
And her ground is by speaking order, speaking order regularize the service of the petitioner against the vacant post of Sri Ratul Kumar Sharma
Hmm.
in the office of the inspector of the school, Nalbari, on 2/3/2009.
Huh.
That cannot be a reason. If Lordship comes to the regularization order,
Huh.
yes, that post fall vacant in
So
2009.
we reject her claim for salary from 2/3/2009. Our question to you was, it was done on the basis of a particular office notification dated 26/6/2013. So prior to that, she would have no right to regularization because her regularization is under that particular notification. Prior to that, she did not have a right. The court granted her that right only under the notification. So anything that happens is after the notification.
Lordship.
Now, in other cases, when regularization proposals have come to the Department of Finance, the proposal for releasing salary was there, or the finance has a certain mindset that this is the date on which the salary would start. We wanted the advice from
That is,
you.
Lordship, another aspect, because it appears, Lordship, this, I mean, prior to her regularization of her service, his service, this was never sent to finance department because nowhere it is mentioned. And if it would have come before the finance
What
department,
we are trying to do is,
this order probably would not have been passed, Lordship.
now there have been affidavits in this case where this has been admitted that the director, while regularizing her service, has not spelled out from when it has to be regularized. The date of effect of the regularization has not been marked. The date of her salary, when it would start, has not been, nothing has been
In the
marked.
absence of any specification to that regard,
Mhm.
Lordship, it has to be considered as prospective.
Now, if it is prospective, we were just trying to find out that if a benefit lies to the petitioner in a manner where other people have been given the benefit of the salary from the date of the notification or date of the recommendation or the date of the order. That is only what we wanted to know from
This is
you.
not pursuant to any notification or any other.
26/6/30.
Yes,
The
this,
court had ordered
No.
that you consider her under 26/6/13,
yes,
do it.
Lordship, I don't want the regularization of the petitioner to be disturbed, Lordship. But my simple understanding is that this is not a case whereunder the petitioner should have been given any benefit so far as the notification of 2013 is
Could be,
concerned.
but that is not under
Because she was not
challenge.
continuing till, not in a sanction post, Lordship. If Lordship comes to the notification itself at page 80.
That part of the arguments we would not like to go into, because yes, you are true.
Yes.
You are correct. We will
Just
take
one
it up.
one paragraph, Lordship.
Yes, should
one
have been
paragraph.
appointed under, should have been working against the sanction post, 10 years, continuous service.
She was
Those
not-
three posts.
She was not having those qualifications.
but it
Lordship,
has
one,
been-
one paragraph, Lordship, just one paragraph above the order portion, Lordship. Order portion, not third, 1, 2, 3, fourth paragraph.
Page number
Page 80, Lordship.
80, fulfills the criteria.
Paragraph,
You
fourth
say this is
paragraph,
wrong.
Lordship, 1, 2, 3, 4.
Huh.
Whereas the petitioner fulfills the criteria laid down in the OM dated 27/6/2013, and a post of the grade 4 is lying vacant in the office of the inspector of school. He is not holding the post. This is another post.
We cannot go beyond one finding of the court.
That is why
Which finding? At page 78.
That is why I am thinking, Lordship, if now this file goes to the finance department, Lordship, the straightway they will advise the education department to cancel this notification.
Not be done.
So what I am saying, Lordship, let her remain satisfied,
Yeah,
Lordship, with
okay, post-
whatever salary she is getting, Lordship.
It is what was in our mind. If you see page 78 for a moment.
Yes, 2013.
It is,
Nowhere it has been decided that yes, she is working against a sanction.
it is not in dispute that the writ petitioner fulfills all the three criteria mentioned in the notification dated 27/6/2013. Page 78. It is not in dispute is the part.
In that
See,
situation,
only this
we
court
would
came to a
have passed an
conclusion.
order, Lordship.
It came to a conclusion.
Yes.
It came to a conclusion. Then because of this, the other order came. It has flown till now. Let the river not be stopped now. Your submission is that
My
this
submission
order
is-
would be prospective.
Yes.
It
One.
would be prospective from the
Secondly,
date of.
although the post fall vacant in 2009,
She would have
as
no
her
right.
regularization was in 2017 only, from 2017 onwards, she will keep getting her regular salary.
Third thing that we have noticed is 2017, she has approached this court in the year 2022.
Yes.
So the 3 years period gone.
Moreover, if he is fulfilling all the conditions, he must have been working against a sanction booking post, and he must have been getting salary till the date of her regularization.
There is another history to this case so far as the pay is concerned.
Yes.
When she first approached the court, there were attempts to give her pay from some other contingent or something like that. This court approved.
In fact, he was
kept-
never in a continuous service, Lordship. Initially, 1995 to 1996.
We will not touch his
From
service.
2004, he was not even getting salary.
We will not touch his service because there is also a judgment of this court that we can reject what has been paid for, but we cannot go ahead to the detriment of the petitioner by taking away something she's already enjoying. We cannot do that. Our only anxiety was from what date, if we record in our order, that this is the
Three
date.
grounds, Lordship. First, she would not be entitled to salary from the date of falling vacancy of falling
Done.
the post vacant.
Done.
Our regularization is prospective, so
Prospective.
there is no question of giving a salary from a retrospective date. And thirdly, Lordship, as the court itself has stated that she fulfills all the conditions, we have to assume that even prior to regularization, he was getting salary. Otherwise, this notification would not have applied.
Mm.
So now she cannot claim two benefits, Lordship. If you are already getting salary, why you are claiming salary again? Something at least you are getting.
Yes. Very helpful. Thank you. It has
Three grounds, Lordship.
eased up matters. Yes, madam, what do you say to that?
My lord, actually, after order, my lord, passed by this director, my lord, then when the petitioner did not receive the salaries from 2009, he immediately approached before this court, and after that,
Wait,
order
in
obtained,
what?
and
In what? Prove what?
For non, for,
In 2019 contempt. In contempt, this court said,
yes, my lord.
give them what is contemplated in the order dated 3rd of October 2017.
17.
3rd of October did not contemplate payment of arrear salaries.
Yes, my lord.
So that would not help you much.
Lordship, kindly peruse 89, page 89. Inspector School wrote a letter to the director regarding proposal for SIU approval.
I understand.
Yes, my lord.
I understand. That is only to get you an SIU approval so that you get the first salary. SI approval is for the first salary, is it not, sir? Thereafter, the finance washes their hands off. There is a post, there is a man, give the salary to the department, it goes to your account. SIU approval is the staff inspection unit approval. The post is there, the staff is there. It is not one post, two people, or a vacant post drawing salary. That is what they inspect. The post creation number is so and so. Madam Devi is drawing salary from so and so. Therefore, that same post number will not be allotted to your assisting counsel. That is what the staff inspection unit says. Otherwise, from 2009, I think we'll have to reject it.
On the day one, revisit, my lord. They have filed an affidavit to revisit.
We will leave it open to them. But that would be allowing them to also go through what Mr. Nayak has now submitted.
It is up to you.
And then if the department then says it is not in dispute part, the finance would say, yes, we were not a party to it. Dispute it, not continuous service because of the present affidavit filed by the page 114. Kindly have page 114. Page 114. I'm sorry, not page 114. Not page 114, I'm sorry.
100.
No. Has not been in continuous service is a specific statement somewhere in the affidavit in opposition. Help us, Mr. Sharma. Help us with a few dates.
He was working continuously, lordship said. Here is, so,
Yes, 139.
139, find out.
What does it say?
Number 4 paragraph. As per report of the inspector of school Nalbari, was calculated that 29 the petitioner bring as works as employee on ground for 1990 and thereafter he has served
Not works as leave vacancy.
as grateful employee
Against leave vacancy. And those periods are marked by commas. 1991 to 1991, then there is a comma. 93 to 94, comma. 94 to 94, comma.
Yes,
Therefore, it is not continuous. And if it is in leave vacancy,
Your lordship, as your lordship pleases.
if it is in leave vacancy, no, madam, if it is in leave vacancy, then only when the leaves are there,
Yes, I know.
then the continuity goes. So let us not give them the option of, let us reject your prayer for allowing them to revisit it. Revisiting may not be conducive. Heard Ms. K. Devi, Learned Counsel, appearing for the petitioner. Also heard Mr. U. Sharma, Learned Counsel, appearing for the respondent authorities in the state, in the Department of School Education. Also heard Mr. P. Nayak, Learned Additional Advocate General, appearing for the respondent number 4, full stop. The petitioner is before this court praying for grant of arrear of salary from 2920 or 2nd of September 2009 to 28th of February 2017. The case of the petitioner is that the petitioner had joined the services under the Inspector of Schools, Nalbari District Circle, sometime in the pursuant to the appointment order dated 1st of October 1991. whereby he was allowed to act as a grade 4 employee. I think we'll have to come back after the break. Did you have your instructions on the other matter?
In meeting, meeting was finished some while ago. So at two by if
And the person who had signed that
yes,
document?
he is also now in the director of.
Mr. Nayak, as an additional advocate general, we just want to bring something to your notice. And if you are in the court, post lunch, what has happened is the court orders suspension period to be regularized by the Director of Secondary Education. Matter is taken up by the Inspector of Schools. Regularized only for pensionary purposes, because of whatever reasons. He approaches this court in a writ petition. Inspector again takes it up, regularizes it for all purposes as spent on duty. Order of the court is to the Director of Secondary Education. Order now is being passed by the Inspector of Schools. First for pensionary benefits. Moment a writ petition is filed, 7 days later, for all purposes spent on duty, this is the money he should get. Was it permissible?
No. I think it's appears 54 or 52 or something. It has to be regularized by the finance department.
Not only that, the Director of Secondary Education was required to take the decision.
Yes.
He is the appointing authority.
Lordship.
Why is the inspector utilizing all his powers?
Is Lordship, your Lordship taking up this matter
At two,
today?
we are having both the officers, the Director of Secondary Education and the Inspector of Schools concerned on VC.
My lord, may I submit, my lord? May I withdraw this petition? No liberty.
Okay, heard Ms. K. Devi, Learned Counsel appealing for the petition, also heard the respondent authority. Attendance to agor order today. The Ms. K. Devi, the instructions of the petitioner, prays for the liberty to withdraw the writ petition in WPC number 5193 of 2024. Although the matter was heard for quite some time, the liberty is granted. The petition closed as withdrawn.
Oblige, your lord.
The other part, if you are available post lunch, we just want to have that discussion because some message has to go. That authorities should not be acting like this. Had the DSC done it, we would have gone into the merit of the order or otherwise. Anybody and everybody is exercising powers.
Lordship, in the meantime, I will go through the file.
I have given him every, I think he has flag marked everything that.
Information, but other three information which is given by the news agency saying with regard to the A and our place original, I got it right now. I will provide your lordship. And with regard to the fact that they have taken the ground, that ground of arrest was not known. It is there, they have annexed the order of the trial court. Their advocate has already been engaged, remand advocate. That shows the moment he appeared here, their advocates are there and he has been informed duly.
Okay. And what about the tickets?
About the ticket, it is as of now, it is, I cannot produce, but the thing is that.
You have time till 4,
but
madam.
he has been brought masked because we cannot disclose his identity there in the airport because their version is that no one knows who was sitting there and the Kavas is there. So it is very difficult to bring him without mask. He has been brought with.
From where?
From Manipur. Airport to Gauhati.
Till the airport?
No, from Manipur airport.
Till the airport. How was he brought? Unless you can show me that time of booking of the tickets, this will remain cloudy. If there is a cloud, presumption. Help us.
But there is no as such.
You want us to,
There
you want to,
ground has been written that when you will arrest a person, then now how he has been brought and how he has been produced, this has to be shown. As of now, I did not get in the law also. You see,
you
the
have,
ground of arrest is.
when the allegation is that he was arrested on the 7th,
He
there
was.
is a law, when the allegation is that he was arrested on the 7th, there is a duty on the part of the arresting authority to show that it could not have been done. It was not done so. You have not given us the press notification. You would give it, you would give it to us a little later. We agree to that. Now, the doubt is whether the person was arrested on 7th or 8th. To show that, just for our satisfaction, come to a conclusion regarding that, a prima facie conclusion. The time of booking of the ticket of the accused would be enough. If it is on the 8th after 9:40, when he was placed under arrest, all good. We will deal with every other situation that the petitioner has placed before us, keeping in account your submissions. Ticket made prior would prima facie indicate that the arrest was prior to 9:40 of 8th. In the face of the facts that there is a specific assertion with some documents produced, which have not been denied by you, that the chaos in Manipur took place on 7th after his arrest, the court would have to presume that the arrest was on 7th, shown on the 8th, and therefore there is a missing link between 7 and 8.
That is the news. News news.
Give us that notification. Why don't you give it to
This is not our notification. It is live
I'm
law.
asking your notification.
No, it is live law. I am giving my notification. Authentic. I'm giving that.
And the tickets.
Press release. This is the press release. And those are by live law. Other two news, it is showing 8. Other two news showing 8. So why one news can be taken into consideration? There are 3 news. Let me, I get disturbed now whenever you ask. Whenever I start with this, you are asking this. I'm finding difficulty.
This is the entire press release given.
Yes, Lordship.
Okay. Then
And this one, this is from live news.
the
And that
government,
is why I have said earlier, it is a press clipping.
the government, where is it?
Such a big organization, they cannot, taking into account all these disturbed area, they cannot lie.
Huh?
And everything is on affidavit. Mandates demand if somebody arrested, he has to be produced within 24 hours. That has done. And if it cannot be produced before 24 hours, then nearest magistrate, that may be their reason. Law demands that only, 24 hours. But all said and done, even if it is 7, it is 24 hours. 8, it is within 24 hours. There are 3 news clipping, 4 news clipping rather. 4 news clipping are matching. It is on 8. Live law is only saying like that. How far it is news dependable, reliable?
Manipur police is not reliable.
That I cannot say anything.
Following his arrest, protests erupt from the evening of 7th June.
So then it is
So just show us the tickets.
that is also 24 hours, within 24 hours.
Just show us the tickets.
But law does not, so far, my little knowledge say, subject to correction.
We'll have it whenever you are next ready. Today itself, whenever you are next ready, the statement, if the ticket is not available, the statements when they were booked.
Beg your lordship.
The statement, a written instruction as to when were the tickets booked. Only that much. That will, if we have it, that will be to your advantage, where we can write down in the judgment that the tickets being booked after the after the time of arrest is proof enough to show that he was arrested on 8/6/2025. Matter will rest. The 24 hours goes. The arresting,
If it is assuming that 7th, it is 24 hours.
the arrest memo is wrong. The information given,
Yes,
the information given to the friends, relatives is wrong. The information given to the petitioner is wrong. The documents given to the petitioner is wrong. The grounds of arrest being supplied 10 minutes before production is wrong. And therefore, immediately on the grant of bail, you would again be at liberty to take him into custody if the law so requires.
Bringing you kindly, Lordship, bear with for a time being. In the order, it is written in the second page, on being asked, the accused person has informed that he is well aware of the fact of this case and ground for which he has been
Madam,
arrested.
given
in the
another,
instant case.
given another order passed in another case, we
Yes.
will read it and you will find the exact same lines.
No, but his
In
advocate,
cases where we have declared that the remand, the arrest and the remand was wrong.
but his advocate was present here. That shows that
So
he
be
has
it.
been informed timely.
So be it.
So by the time he reached here in the court,
We required a video to one correction. Now, these are discussions you are dragging, which we do not want to drag into. And it is only because this order is reserved. List on day. List on Monday for delivery of orders. Delivery of orders.
meanwhile, I may be given opportunity, your lordship.
The documents, in case the learned counsel for the CBI desires to produce the documents sought for by this court, she would be at liberty to do so prior to the closing hours today.
Lordship, I
Yes,
have
next.
few judgment to be relied upon, few judgment.
Judgment kin lo to.
Always looked.
So are they joining on the VC? VC permission to do. Mr. Nair, will they get this thing settled? Have you gone through the documents?
Yes, Lord.
See, is it the proper way of handling things and not
Yes.
giving rise to unnecessary litigation?
Yes, the competent authority being the appointing authority.
Has to be the director
Order
of
passed
secondary
by the
education.
inspector of school is not an appropriate order.
And in the affidavit in opposition, she has controverted what the inspector of school has done
Yes, Lord.
and yet not proceeded to set it aside. Has not sought the liberty to, from this court to say, we are taking that order back.
But there is a reason, Lordship.
Hmm.
Because this person retired in the year 2023. And in the meantime, Lordship, it's more than 1 year, Lordship. After 4 months, Lordship, we cannot initiate departmental proceeding also. So that 4 months period has also lapsed, Lordship. So that is why he is praying for liberty to be granted by this honorable court so that we can initiate a departmental proceeding and take an appropriate decision.
See, when
Probably that is the intention.
pendency, when there is a litigation pending in the court, select lists get extended. When there is a pendency in the court, that time period is usually taken away for everything.
Yes.
Even for an appeal,
Yes.
even to go for a fresh litigation, even to approach the appropriate forum. So that liberty we can grant. That since it was a litigation pending here,
Lordship will set aside the order passed by the inspector of school, Lordship, and allow the authority to initiate a DP and take
no, we'll allow them to take an appropriate decision within a period of 15 days.
Yes. Yes, Lordship.
Within a period of 15 days, they will take whatever decision they have to take. They want to start a DP, they want to do anything. And it is with the permission of the governor.
Yes, that will be required after retirement.
After retirement, and it has to be done within 3 months.
So if this is, taken as a continuous process, Lordship, then probably
the governor's
approval.
pension fund direction. Let us be sure for a minute.
It will be
22,
in the department, I'm Assam Services Discipline and Appeal Rules. Lord.
22. এখন আসাম সার্ভিসেস কোন ম্যাক্স অফ দেখুন
আছে না authorized.
নেই তো। এখন পেনশন ম্যানুয়াল লাগে। Renewable. Lot of-
when did you retire?
Have retired on 1/1/2023.
1/1/2023, 4 years, sir.
4 years.
Previously, 95, 175.
So one I certificate.
After 4 years, even the governor goes. Prior to 4 years, none of the governor. If he was not
Yes,
placed,
it is not months, lots of years. Lord.
Years.
Years.
one part.
Yes.
Second part, he was under suspension. He was placed under suspension.
Yes.
That suspension was revoked by an order.
Suspension, one reinstatement order is also there. Lord.
That reinstatement order is by the IS,
Yes, Lord.
which also has to go.
With approval, it is
Suspension
written as
continues, but in the absence of a review,
Review is not there.
so we are on the suspension part only to see whether it has already been
My
initiated.
understanding will be, even if the reinstatement order is not touched, Lordship, thereafter, what to do with the service during the suspension period? In that regard, Lordship, let the authority take a decision by the competent authority, Lordship. In the meantime, Lordship will set aside the order passed by the inspector of schools, Lordship.
Yes, let us have a discussion with the person concerned. Yes, madam, good afternoon.
Good afternoon, my lord.
Yes. Have you seen what has happened in this case?
Yes, my lord.
The orders were for you to pass a necessary order on the suspension period.
My lord, we have requested Honorable Court to give us a permission
Ah,
to visit the IS order, reinstatement order.
no, the reinstatement order was not passed once, madam. It was passed twice.
So, my lord, that has to be revisited since the matter
Now,
is before the
now
court.
when you are the appointing authority, why the liberty to field officers to usurp your powers?
My lord, the petitioner was asked to submit a representation before the undersigned, which he did not do.
Ah,
And once the matter was placed before the court, then only the matter has come to our notice.
no. Let us again see. Do you have the pleadings before you, the writ petition and the affidavits?
Yes, ma'am.
Can you have page 38 for some time?
Date of writ petition.
Give me
Of
one
the
minute.
writ petition.
Writ petition to diya suno. Writ petition. Yeah. Writ petition to diya suno. This is my affidavit. My lord, writ petition is before me.
Page 38.
Page 38. Page 38. Annexure 6. 6. 1.
Annexure 6.
Oh, 38. 38. Did you read petition order today? Oh, I got it. Annexure 6. Yes, my lord.
Page 38.
Yes.
The last paragraph. Representation
hearing-
through the inspector of schools to the director of secondary education.
After hearing the learning council, parties considering the agreement of the education is disposed of the nomination state, petitioner to submit a represent before the data. Yes. কিন্তু অহা নাই এইটো আমাৰ তাত ডাইৰেক্টলি IS তাতে তেওঁ পাই কি কৰিলে IS তাতে ৰিইনষ্টেটে কৰি দিলে
হ'ব আপুনি লাহে লাহে ডিছকাছ কৰক
Now page 39. The last paragraph.
In the event.
Yes, my lord, that is not done.
Now, do we have the concerned inspector of schools available?
Yes, my lord.
Yes, my lord. He's online session.
Where
Yes,
is he?
Yeah,
Where-
he is here. Come this it.
Yes.
Yes, sir. You have passed an order on 9/12/2022,
Yes, sir.
where you have said in compliance of Honorable High Court's order passed on 13/6.
Yes.
Order of 13/6 did not authorize you to pass any orders. It was the director of secondary education who was supposed to do it.
That was a big mistake from my part, my lord. Please pardon me.
Now, by this order, our pardon is okay, but this order has given the right to the petitioner to, on the face of a record where he was not found,
Yes, my lord.
there is no DP drawn against him. All the period has been regularized, treating the said suspension period as on duty, entitling him to everything. And then all calculations are given. This is a litigation which could well be avoided from the year 2022 onwards, at least. Our only observation would be that care needs to be taken when dealing with service-related matters in the department itself.
Yes, my lord.
It is not a very good sign to say that a separate bench has to sit down to look after what the education department grievances against the education department. That is all we can say today. Madam Director,
Yes, my lord.
in every case where we find that a particular order is not in consonance with the, is not acceptable on the face of it, it would be better if your officers or your team apprises you of the same. We cannot go through every order to see that which was the wrong order. And people, anyway.
Lordship, may I submit that? Lordship will keep this matter.
Okay, you may leave for now.
Lordship, just for a moment, just for a moment.
Be there, yes.
Let this matter, Lordship will
Pending.
keep this matter pending. On the basis of the submission made by the director, Lordship will adjourn this matter. In the meantime, they have given assurance that they will, in the meantime, relook the order passed by the inspector and take an appropriate decision in this regard. A fresh cause of action will arise, Lordship. He will also get an opportunity to challenge. In the meantime, Lordship will keep this matter as part of Lordship. Let the authority take a decision.
That is a good option.
And in our affidavit also in paragraph 12, it is mentioned.
That is why we had required the presence when the affidavit, the department comes up to say that it is a wrong order and thereafter nothing is done.
That's why
Nothing is done to set it right. In the reply, there is another order dated 9/12/2022. That is not addressed to, this is something new in the writ petition. After the affidavit in reply, the department has the right to come up with an affidavit or an application if things not present in the affidavit, in the writ petition have been brought to notice by the affidavit in reply. A liberty can be paid for. That is why counsels, that is why advisors. These are not run of the mill cases. In usual parlance, they are coming and going before the court. Someone not attending for a few days, what to do with the absence. These are not those cases. These are cases where a person is suspended because of criminal activities alleged against him. And then because no DP is drawn, all regularized. With power comes responsibility. With uneasy lies the head which wears the crown. You have the power, you have the crown, you have to be very uneasy about it. Cannot be I have a sword and I'll become the cartoon character He-Man. I'll do whatever I want to. Power has to be used properly. This is the 5th or the 6th case
Lordship.
where these kind of things are coming up. Inspectors, deputy inspectors passing orders. It has always been there, but no one has taken a note of it. It all becomes one particular case. In this particular case, this kind of an order came. And then it goes, it shuts down. There are other departments up and doing, knowing the law.
No,
doing
I
it
don't,
properly.
I don't think that the inspector, concerned engineer, the inspector present there, he is not aware of the law. I don't know for what reason he has passed this order beyond his authority, Lordship.
And this is after filing of the
I'm
writ
not,
petition.
yes, Lordship. I'm not sure that he is not aware of law, Lordship. He's fully aware. In spite of that, he passed that order.
And then the proposals for area salary,
Same person forwarded.
huge amounts.
Yes. So at this moment, Lordship, I pray your Lordship to keep this part heard. Lordship will take up this matter. Otherwise, if bench is changed, Lordship opinion may also get changed.
It may be not be good. Yes, heard, Mr.
Yes, Islam.
S. Islam, Learned Counsel appearing for the petitioner, also heard. Mr. U. Sharma, Learned Counsel appearing for the Department of School Education. Mr. P. Nayak, Learned Additional Advocate General, has appeared in the matter at the request of the court. The Director of Secondary Education, Ms. M. Hujai, and the Inspector of Schools, Korpeta District Circle, who had passed the concerned order dated 9/12/2022, and the earlier order, where is it? 15/7/2022, namely Mr. M. Kakoti, are also present before this court through PC. This court, while going through the records, has come to has noticed that the petitioner was placed under suspension by the order dated 6/5/2015 and subsequently by order dated 17/9/2018. He was reinstated and he joined his duties on 29/2018. And since then, the petitioner has been discharging, as per his assertions, his duties till today. Where is that order
Correct.
revoking the suspension?
The total, your page 20, your Lordship. 20.
The suspension of the petitioner was revoked by the order dated 17/9/2018 by the orders of the Director of Secondary Education, which was communicated by letter number GIS oblique DSE oblique CC oblique 16 oblique 2018 oblique 75 dated 21/8/2018. Stop. It is not placed before this court as to what prompted the just a moment. You had an earlier order.
No, no, this is.
There was an earlier writ petition.
Yes, no. No, that order is, I filed an appeal, next page 18, that appeal is disposed of by the same day. Page 18 that was.
Just a minute. We shall see. More things are coming up. See, just because a school has been amalgamated, his suspension is removed.
Yes. And accordingly, in the second case, Lordship, direction was issued to the secondary, director secondary,
Ah.
to dispose of the representation. Earlier representation was by the elementary. That was prior to amalgamation, I think.
Records of the case reveal that pursuant to the orders passed in WPC number 4352 of 2015, the Director of Elementary Education, which was the appointing authority of the petitioner at that relevant point of time, had passed an order requesting the Director of Secondary Education and the Secretary of the Government of Assam Secondary Education Department and the Director of Secondary Education Assam to take necessary steps to reinstate the petitioner in his service in the original substantive post for the benefit of students, keeping his reinstatement subject to outcome of the criminal proceeding and departmental proceeding, if any. Full stop. The reasons for the Director of Secondary Education requiring the petitioner to be reinstated in service by the order dated 21/8/2018 is not placed before this court. Full stop. By the next date fixed, the Director of Secondary Education shall ensure that the said order is placed before this court. The relevant notings in the said, the relevant notice leading to the passing of the aforesaid order is placed before this court. The petitioner then approached this court by filing WPC number 1286 of 2019, praying for payment of arrears, payment of salary for the period under suspension. And this court, by the order dated 30/8/2019, observed that such direction could not be issued until a final order is passed on conclusion of the departmental inquiry in the criminal proceeding against. Go back to the sentence. Only after the final order is passed on conclusion of the departmental inquiry or the criminal proceeding against him in accordance with law. By the order dated 30/3/2022, the trial court had acquitted the petitioner of the charges leveled against him in the criminal proceeding. Full stop. Till such time, no departmental proceedings had been initiated against the petitioner. The petitioner again approached this court by filing WPC 3466 of 2022, passed in claiming the regularization of his
Suspension period.
Period of suspension and for regular salary for the aforesaid period. This court gave liberty to the petitioner to approach the authorities within a period of on or before 30/6/2022 by filing a representation to the Inspector of Schools which was required to be forwarded to the Director of Secondary Education, full stop. The Director of Secondary Education was required to pass to dispose of the said representation with a recent order after considering the relevant records and documents as well as the proceedings of a departmental inquiry, if any, conducted against the petitioner, full stop. Today, the Director of Secondary Education has informed this court that the Office of the Director of Secondary Education has not received any application filed by the petitioner on or before 30 June 2022. The petitioner has not made any statement in the writ petition that he had filed an application as required by this court by the order dated 13/6/2022, full stop. The Inspector of Schools, Borpeta District, passed an order on 15/7/2022, whereby the suspension period in respect of the petitioner was regularized with effect from 21/2015 to 19/9/2018, full stop. The order dated 13/6/2022 had required the Director of Secondary Education to take a call in the matter, and it is not revealed from records placed before this court as to why the Inspector of Schools, Borpeta District Circle, took it upon himself to pass the order dated 15/7/2022. It may be so that the Inspector of Schools, Borpeta, at that particular relevant point of time was not aware of the order dated 13/6/2022 passed by this court, and on being informed, may have perhaps, on being informed of the requirement of regularization, may have passed such an order, full stop. Be that as it may, the Inspector of Schools, Borpeta, would be at liberty to place before this court by way of an affidavit the reasons as to why the order dated 15/7/2022 had been passed after the repetition aforesaid had been disposed of by this court, requiring the Director of Secondary Education to dispose of the representation of the petitioner, full stop. The writ petition thereafter contains a letter public representation dated 15/10/2022 by the petitioner addressed to the Director of Secondary Education, Assam, which was sent by registered post on 31/10/2022. Praying for release of his salaries for the period with effect from 1/4/2015 to 28/2/2022, full stop. When will you vision? Just a minute, don't write anything. So your suspension was reinstated. You were reinstated on 17/9/18. You were not paid any salaries from 18 to 22.
That this statement is shows that.
No, you tell us your statement. Were you not paid salaries from 18 to 22?
Well, I paid some due to not regularize, he's received some.
Sorry?
Less in it. He received salaries, but due to non-regularize that period, he's received less salary when fixation is some, but it is retained.
In this application, you have sought for salaries from area dues from 1/4/15 to 28/2/2022.
Lordship. Page 75, Lordship is clear. In page 75 of the evident reply, Lordship document.
Page
75
of the
evident reply. Turning page. Lordship.
No, the area salary.
Paragraph 13, Lordship.
Page 41.
The 75 non-rural certificate is there from the headmaster. Page 75.
From page,
Page 75, non-drawal certificate of the
what
headmaster.
is your total pay? 34,000. Page 42. Okay. Praying for release of area salaries for the period from 1/4/2015 to 28/2/2022. The writ petition was filed on 1st of December 2022. By filing an affidavit in reply to the affidavit in opposition filed on behalf of the respondent, the petitioner has brought on record a proposal submitted by one Ratul Kumar Das, AES-1, in charge Inspector of Schools, BDC Borpeta, issued on 22/3/2024, whereby a resubmission of area particulars in respect of the petitioner was forwarded to the Director of Secondary Education, Assam, Kahilipara, Gauhati 19. A non-royal certificate was also issued by the headmaster. A non-royal certificate is given by the headmaster or by the Treasury officer.
Generally, it is treasury officer.
Ah.
In this case, it is by the headmaster lordship.
Is he authorized to do so?
It is
Kora আছে না পিছফালে?
that counter assess.
কোনটো?
And you see the note there. No individual record is maintained in the treasury. That is what he has signed.
These are not legible.
Counter sent by the treasury.
Note, no
Note is-
individual record is maintained in the treasury.
Treasury is meant.
The petitioner has also brought on record an order dated 9/12/2022, which has been passed after the filing of the present writ petition by the Inspector of Schools, BDC Borpeta, where the inspector has passed an order reviewing the earlier order dated 15/7/2022 and ordering that the service of the that in compliance of the court's order passed on 13/6/2022, the suspension period of the petitioner was regularized for all purposes, treating the said suspension period as on duty. It is on the basis of these letters that the petitioner has reasserted his claim for arrear salaries. There is another order on record. There is another communication on record from the Deputy Director of Secondary Education, whereby the Inspector of Schools, BDC Borpeta, has required a resubmission of the arrear particulars, pointing out certain discrepancies in the arrear amount. Stop. Requesting the Inspector of Schools, BDC Borpeta, to resubmit a fresh proposal to the Office of the Director of Secondary Education, full stop. The Director of Secondary Education in the affidavit filed has referred to a hearing conducted by the Director with regard to the claim of arrear salary of the petitioner. During the hearing, it emerged that no departmental proceeding had been initiated against the petitioner. A further stand was taken that where is that that order may not be appropriate. We read somewhere, na?
At para 12.
At para
Page 52 bottom.
Page 52.
50 bottom.
The director in the affidavit file has stated that the order dated 9/12/2022 issued by the Inspector of Schools, NDC, BDC, Borpeta, was a mechanical order issued without evaluation of the rule position as referred to in FR 54 within bracket capital V within bracket capital 3. Further, the director has stated that there is no indication that any competent authority had recorded the suspension of the writ petitioner was wholly unjustified. It has been asserted that the acquittal of the petitioner in the criminal case was not or did not amount to an honorary acquittal. The permission of the court has been sought for to initiate departmental proceeding against the petitioner for his misconduct and further to be allowed to revisit, re-examine, recall, and interfere with the earlier order dated 19/12/2022 issued by the then Inspector of School, Borpeta. The learned Additional Advocate General, on a request made by this court, has submitted that who appears at the request of this court has submitted that the order dated 9/12/2022 is not a lawful order in as much as the Inspector of Schools is not the appointing authority of the petitioner who could have regularized any period of absence from duty for whatever reasons that may be, comma. Also because this court had directed the Director of Secondary Education to take a to decide the representation of the petitioner. Full stop. He also points out that the petitioner did not prefer the representation as required by the order dated 13/6/2022 to the Director of Secondary Education through the Inspector of Schools, and was satisfied with the orders which were earlier passed by the Inspector of Schools, regularizing the period of suspension for the purposes of pensionary benefits only. This court does not, next paragraph, this court does not approve of the manner in which the matter has been handled at the departmental level. Stop. Without commenting much for the present, comma, this court grants the liberty to the Director of Secondary Education to revisit the to take up a review of the order dated 9/12/2022 and of the order dated, what's the early order? 15/7/2022. Is it? 15/7/2022 passed by the Inspector of Schools, BDC, Borpeta. And after taking into account the records as available in this writ petition, comma, the records of as available in the office of the Inspector of Schools, and also the records which are available in the office of the Director of Secondary Education, comma, to take a comprehensive view and pass necessary orders with regard to the manner in which the period of suspension of the petitioner is required to be dealt with. Full stop. It is submitted at the bar that the petitioner has retired from his services on
1/1/2023.
1/1/2023. It is noticed that a period of 4 years as required under the relevant provisions of the pension rules have not yet elapsed, which shall also be taken into account by the Director of Secondary Education. Please. What more is required? The records of the case do not reveal as to why immediately after the orders passed by this court on 13/6/2022, the statement of arrear salaries for the petitioner for the period from 1/4/2015 had been prepared by the headmaster of the school, even when on 15/7/2022, the period had been regularized only for the purposes of pensionary benefit. The order dated 15/7/2022 did not reflect that the period would be counted for services or service benefits, except for pension. We leave it upon the Director of Secondary Education to cause such enquiries as may be required regarding the action of the headmaster in preparing arrear statements for arrear salary and forwarding it to the departmental authorities for further action.
Lordship, may I submit, Lordship?
Mm.
This stage, Lordship may not like to make any comment as regard the benefits, pensionary benefits, Lordship. Let him keep getting the pension, but it will be subject to outcome of the order to be passed.
No,
by the director.
we are not making anything on the pensionary benefits. What we tried to communicate was this. The order of 15/7/2022
Yes,
says for pensionary benefits, services regularized.
yes.
I'm not setting that aside as of now. We are not interfering with that in any manner as of now. Even if we take that order to be a correct and lawful order for the time being, the headmaster sends a arrear salary proposal. What made him do it?
Yes.
There was no direction from any authority that we are going to pay arrear salaries. Please send us a proposal.
Yes.
Why did he do it? It is these
Yes.
headmasters who start sending the proposals and the district authorities start forwarding them.
Now, what I'm trying to emphasize, Lordship, if this order 15/7/2022 is set aside,
I'm not setting this.
if the authority decides to set aside this order, Lordship, then he will only get provisional pension, Lordship. Because in that situation, his pension will not be finalized. So Lordship will keep that option open.
We'll ensure that they do not interfere.
Let him keep getting the
We
pension.
will ensure that they will not interfere with the order dated 15/7/2022 without leave of the court.
No, let the authority take a decision, Lordship. So far as 15/7/2022 and 9/12/2022, let the authority revisit and take a decision, Lordship. Let him keep getting pension, Lordship.
We'll ensure.
But it will be in the subject to outcome of the order to be passed by the
We'll
director.
We'll put that.
We don't want to disturb his pension, Lordship, but it will be subject to outcome, Lordship.
Of course.
Because most probably authority will set aside this order of 15/7, Lordship.
We'll record that in the state.
Yes, in that situation, he will only get provisional pension.
Next paragraph. It has been pointed out by the learned Advocate General that in view of the orders passed today, there might be a situation where both the orders dated 15/7/2022 and
9/12/2020.
9/12/2022 may incur the interference of the departmental authorities. Full stop. It is made clear that these are interim orders being passed in this writ petition, and the petitioner and the receipt of pension by the petitioner at this stage should not be hampered in any manner by any decision which the department, which the Director of Secondary Education may now take as per observations made in this order. Full stop. If any of these orders are required to be set aside, the same be done after the justification and the proposals are placed before this court on the next date fixed.
No, Lordship has already granted liberty to revisit these orders. Lordship has already granted. What I am saying at this stage, if these orders are revisited, Lordship, and authority takes a decision to set aside these orders and pass a fresh order that without completing a proper DP, Lordship, this period of suspension is not going to be regularized for any purpose, Lordship. Only after DP, Lordship. But in the meantime, he is getting pension. What I'm submitting, Lordship, let the authority take a decision, let the authority complete the DP. Lordship may not record that. But in the meantime, he will keep getting the pension, but same will be subject to outcome of any further order to be passed by the
Can
authority.
you strike out the next earlier part?
My lord, it should not be interfered regarding the revisit of the order, my lord.
We have not interfered with
Yes, yes.
anything. As of now, we have not
Lordship will-
interfered with anything.
Department report.
In the event the Director of Secondary Education is of the opinion that the in the event the receipt of the pension by the petitioner during the pendency of this litigation will remain subject to outcome. We don't need to do that now, should we? We are having it again on the next date. They will revisit the order and do what?
If they revisit, Lordship, and take a decision to set aside the regularization of the suspension word, the moment that decision is taken, his pension will be stopped, Lordship. That is why I am giving him that much at this comfort.
How do we say that even in the event the DSE decides to revisit the order or to
Regularizing the period of suspension for the purpose of pension. That order is there. If that is set aside, an authority takes a decision, such decision will be taken only after completing the DP. In the meantime, he is getting pension. That is what I am submitting, Lord.
the moment it is revisited?
Yes, they will definitely revisit. They will set aside and they will start a DP and a decision will come. Till then, Lordship, he will keep getting pension, but it will be subject to outcome the further decision to be taken by the authority. That much only, Lordship. Otherwise, on next date, Lordship, court will ask me if no such decision is there for regularizing the period of suspension while you were paying pension.
No. That much if we are keeping it part of that much we will remember that.
I'll leave it to you.
That much we will remember. It is made clear that the pension which is now being drawn by the petitioner will not be affected by any decision of the Director of Secondary Education taken during the pendency of the litigation. Full stop. Further orders as required would be passed on the next date of listing after the decision of the Director of Secondary is before this. So list this matter again on. Yes, madam, how much time?
My lord, 3 weeks.
3 weeks or no, apni alop long sir.
মোৰ ইলেকশ্যনো আহি আছে ইলেকশ্যন বহুত কামো আছে
We tend to hear the word eviction rather than election. Yes. What is the next date? At your convenience.
Six weeks. My lord, give me
আজি কি তাৰিখ 7 তাৰিখ
last week of March. My lord, last week of March.
Last week of March.
ইমান লাগিব
অকমান schedule tight মোৰ খুব
Lordship.
Yes, give us a date. Give us a particular date.
30, my lord.
30th of March.
Yes.
On the 30th of
30th.
March 2026. Full stop. The Director of Secondary Education shall ensure receipt of appropriate instructions by the Learned Counsel appearing by Mr. U. Sharma, Learned Counsel appearing for the Department of School Education. The Learned Standing Counsel shall be at liberty to inform the Learned Additional Advocate General regarding the listing of this case on the next date of listing. for convenience. List again on 30th of March 2022. Yes, madam, thank you. Thank you.
Obliged, Lordship.
So one thing, your lordship mentioned that I have not submitted representation. Maybe in reply I have stated after High Court's order, he submitted before the IS inspector. After High Court's order 13/6/2022, it was submitted represent before the.
File to.
In my reply, I have stated.
You have stated. You see, when you are standing on quicksand, you should not be struggling. What happens, do you know? Slowly and slowly sink.
66. After that.
There is a statement.
Statement.
Kindly show us a receipt.
Sealed.
A receipt copy.
No, that one. Page statement is there here. He has not copy, has not with him.
Page
66.
66.
I reply. Top here. In pursuance to order dated that appellate submitted representation before the district inspector for a suspended period. Thereafter, the inspector passed 15/7 66.
Paragraph 6 is a matter of record. Kindly show us the receipt copy.
No, your
You will be at liberty to show us the receipt copy,
No, your
because we will have to see whether that receipt copy contained a certified copy of the order of this court, which required the matter to be forwarded to the DAC. If it was present there, then the concerned person who passed an order, when the DAC was required, will be in trouble. If you manipulated that copy, requiring respondent authorities to do it,
copy is not
then you would be in problem. Show us the copy.
Copy is not there.
Starting to sink.
Copy is not there.
You said records. False statement made on affidavit. Which record did you, is he referring to? Which record is he referring to?
Record is not there.
Tell us. From where did he say it is a matter of record? I am swearing it as a matter of record. The in charge IC at that point of time does not talk about the writ petition. He does not talk about your application. He talks about nothing. You say records. In your writ petition, you do not say that you submitted a copy. You say after the order was passed, inspector did it. Records. We will reject the entire affidavit in reply right now.
Sorry.
Should we? We will record that in the order.
Sorry, that is not there.
Quicksand. Always remember quicksand. No struggles. Peace and calm. There will be a solution. I'll do it.
Bless.
That I will dictate the judgment. We can have. Madam, yes. Yes, madam.
CP 7.
Available. Is it in the PDF format or is it? It is in a file. A flag mark. Hand it over to the court master. You have to hand it over to the court master. Number one. Number two. You are still again asking, although we have passed an order. Any statement when the ticket was made? It is difficult to answer. For them. For them. They would. We are again at the risk of repetition. Not for an instance, the motive is questioned. Not for an instance, the incident is questioned. Nothing is in our mind. Only difficulty is when we write down an order, we have to specify few things. And whenever we cannot specify something, this your department has to understand. When we cannot specify things, then there is a doubt. When there is a doubt, law requires in criminal proceedings, except in under certain acts, the benefit to at least tilt. Yes. on the same incident, not on the snatching away of the arms, but on the incident which took place with two of the ladies, there are rejections by the court. Rejections by the court when equality was being prayed for, but the gravity of the offense. We have that in mind. There is no doubt about it. We will not only look, we don't have to look only into the arguments, we also have to look into the gravity of the offense, the chances that the person may flee away, that he may influence people, what kind of an influence he would have once he's outside, all those things. I know the list. Have you seen the list? Runs into pages.
They have exit the arms. They have. If you release, you will fit the arms.
Then there are also provisions in law where the threat is there, what to do. When this is there, what to do. When that is there, what to do. Is it not?
This is exceptional and the
Yes, the Supreme Court has said, please transfer everything to another state so that it is not influenced at all.
CBI people. They could not. Which we cannot bring in the record now.
There are many things. I know. We have been on that side till quite some recent times. Now proceedings being public, it's a different issue.
It's sentiment is
We understand.
the way they have suffered.
Whatever you have given and whatever they have argued, we would do our best to have a decision on that to the best understanding of law.
Situation is like.
Yes.
Has been asked. There will be a, I think, airport also.
We'll look into it, madam. Some things we cannot take into consideration. Thank you. এখন হে ফাইলটো বান্ধি দিব for Monday রাখিছো নেকি delivery for us. Yes, this is item number 4 and 5. Huh? 4 and 5. 4 and 5. আপুনি সেইটো লৈছিলে এটেন্ডেন্সটো ৰাতিপুৱা মিষ্টাৰ পিপি দত্ত আছিলে This petition has been filed. লিখিছো Help us with the dates. Which is the second petition? 6466.
3531 is the
Second petition. It will contain all the details.
yes, sir, and item 5 is the first.
This petition has been filed by the petitioner assailing the order, not assailing
Page 80, Lordship.
assailing the order dated 8/11/2023 passed by the Director of Secondary Education, Assam, whereby the respondent authority had cancelled the promotion of the petitioner, also assailing the inquiry report based on which the order dated 8/11/2023 assailed in this petition had been passed, and for reinstating the petitioner in the post of headmaster of a high school as a consequential relief to the setting aside of the orders aforesaid. The genesis of this writ petition lies on an allegation leveled upon the petitioner that he had manipulated the date of his appointment in his service records, for which an inquiry had been initiated against the petition. The records with the writ petition reveal that the petitioner had been appointed
Yes, 30.
on 9/10/1990 by the Secretary of the Janata High School, Nam Sisu, and he had accordingly joined the school on 10/10/1991. Full stop. The
1990
school,
Lordship.
huh?
1990 Lordship.
1990, full stop. The school came to be provincialized in the year 1991.
One Lordship.
And after provincialization of the services of the petitioner along with other staff of the school, the inspector of schools, Jorhat District Circle, Jorhat, by an order dated 30/5/1992, approved the appointments given by the school managing committee. Full stop. While, just a minute, huh? Can you read the Assamese version, sir?
Lordship.
It has been translated by some manner.
Borpeta Zilla. This some my part.
ইয়াৰ উপৰিও পৰিচালনা সন্নিবিষ্ট দিয়া নিযুক্তি কি দিয়া হল কিবা দিয়া হল ন apart from this the appointments by the managing committee had also been approved. That is what it is
Approved,
saying.
Lordship. All the staffs of that school. Lordship.
Just hold on for another minute, huh? What is this
Annexure 3, Lordship.
Nusanok Tarikh, or what is this? What is this?
Lordship, Annexure 3, Lordship.
Huh?
Annexure 3, Lordship.
Page 40 I'm trying to read.
40, Lordship. Page 40, Lordship. This is the Lordship approval letter, Lordship.
Pradhan Shikkokor Pod Khali.
Yes, yes.
Thereafter, just above that, Shikkok aru Kormosari Nam. Then what is the next word written?
Shikkok aru Kormosari Nam.
What is the next word?
Dormoha.
That is the last.
Last.
In between, what is that?
Why?
If you have no other matters, you may leave. In this matter, PP Datta had appeared. So
PP Datta appeared.
there's no issue. He had made a request, so you may leave if you want.
There is with effect from, Lordship. With effect from. From
I don't know.
11, Lordship. 1911-91.
Further, did I say the further appointments given by the school managing committee were approved? Huh? Stop. Accordingly, a service book of the petition, a service record of the petitioner had been initiated, which was initialed by the Joint Director of Secondary Education, Assam. Stop. The allegation leveled is that against the name of the in the service records maintained by the school, the date of appointment of the petitioner was shown as 5/2/1991, and there is a handwritten correction made to the effect that the date of appointment was of 10/10/1991. The record produced with the writ petition does not reflect an overwriting, but shows that the date of 10/10/1990
Is handwritten.
has been written
And in hand.
next to the date 5/2/1991. Stop. The services of the petitioner and other serving teachers in the acquaintance rule of the was confirmed by the Inspector of Schools on 1st of October 2008. The petitioner thereafter had been promoted to the post of head teacher of the Janata High School by the order dated 5th of August 2017. Relevant to state here that the original school in which the petitioner had been serving had been amalgamated.
Lordship, not amalgamated, it's in high school only.
Originally also it was a high school.
High school,
And we did not say Janata High School, we said some other school.
Lordship,
Did we say Janata High School? What about Janata High School question?
Janata High School, Lordship.
Janata High School, no?
Naam
Then we don't need that. Then we do that. The petitioner, being the senior most, had been promoted as the
head teacher,
head teacher of the
Janata High School.
Janata High School, as the headmaster of the Janata High School. On 6/9/2018, the petitioner was served with a notice requiring him to show cause as to why no, show cause not to show cause, the petitioner was required to submit a satisfactory written explanation on complaints received by the disciplinary authority cum director, Secondary Education, Assam, on complaints received that the petitioner had manipulated the records of his date of joining and submitted the same at the time of selection of headmaster during the year 2015-16 and had got selected or appointed as regular headmaster of the Janata High School. The petitioner was thereafter summoned to appear before a hearing on 30/11/2018, another hearing required to be held on 3/1/2019.
31.
Full stop. On 31/2019, there's a 3. 31. On 31/2019, the original service book in respect of one Mohendranath Datta and of the petitioner were seized till disposal of the matter. After holding an inquiry, allowing the petitioner to give his statement in the matter, the order dated 11/9/2020 was passed by the Director of Secondary Education, by which the petitioner was placed under suspension with immediate effect. Stop.
Pending departmental.
This order was passed with a recording that the suspension was imposed pending trial of a departmental proceeding. The petitioner thereafter filed a appeal under Rule 14 of the Assam Services within bracket Discipline and Appeal bracket close Rules 1964, praying before the Director of Secondary Education for a reinstatement in his service. The application was received by the Office of the Director of Secondary Education on 20 9/9/2020, full stop. On 23/11/2020.
I think that 24/9. Its date will be 24/9/20.
24/9/20. On 23/12/2020, the Director of Secondary Education issued a show-cause notice to the petitioner, stating that while he was working as an assistant teacher in Janta High School, he had manipulated his original date of joining. Stop. The second charge level was that he, while working as an assistant teacher of the Janta High School, he had misguided the authority by manipulating official records with ulterior motive. Third allegation level was that while working as an assistant teacher in Janata High School, he had manipulated official records during the exercise for promotion to the post of regular headmaster by recording the date of joining as 10/10/1990 instead of 5/2/1991 in the relevant papers by overwriting he was charged with serious negligence and dereliction of duty for. What is negligence? When you don't do something. What is dereliction of duty? When you don't do something after being ordered to do so.
Knowing.
You have manipulated it. How can it be negligence?
That's in criminal sense also, I don't think so.
Huh?
In criminal meaning also, Lordship, I don't think it's negligence. Anyway, Lordship. Next page is Lordship statement of.
The statement of allegations, comma, the list of documents and the list of witnesses were supplied to the petitioner along with the memorandum of charge. The reply to the show-cause notice by the petitioner was submitted on 21/2021.
It is not reply, Lordship. I am apply for documents
Then
inspection, Lordship.
no, last sentence cut out period. On receipt of the aforesaid show-cause notice, the petitioner prayed before the disciplinary authority to be allowed to inspect the relevant documents for the purposes of filing his written statement. He filed the reply to the show-cause notice on 12/4/2021, where he made a specific assertion that copies of the documents sought for to frame the reply to the show-cause had not been served upon him. And he was filing the reply to the show-cause notice under serious handicap, full stop.
I have given parawise reply in case 74/75, Lordship.
The petitioner in his reply had submitted that the records of which manipulation had been alleged were that he was not the custodian of the records of which manipulation had been alleged. And these being official records, he would have no opportunity to manipulate any such record. But he asserted that he had joined duty on 10/10/1990 and it was an appropriate authority who might have made the requisite noting in the service record on realizing that the petitioner had joined his services in the then unprovincialized school on 10/10/19. Basically, the petitioner pleaded absence of ACCESS, access to the official records in order to enable him to manipulate records. The petitioner was called for a hearing on the 18th of September 2021, along with the Inspector of Schools, Jorhat District Circle, Jorhat, the presidents of the SMDC of the Janata High School, and one Mr. M. Nath Dotto, assistant teacher of the Janata High School, Nam Sisu District, Jorhat. The petitioner thereafter preferred WPC number 430 of 2021, in which the suspension order of the petitioner had been interfered with by this court on the ground that the said order placing him under suspension could not be sustained after expiry of 90 days without being reviewed any further. It was left to the wisdom of the department as to whether to proceed further with the disciplinary proceeding against the petitioner. The Government of Assam in the Department of School Education issued an order dated 11/10/2023.
Lordship, may I interpret, Lordship? In the paragraph 10 of that order may be relevant, I think.
Which order?
Lordship, page 81, Lordship, that interpret the suspension order, Lordship. Paragraph 10, Lordship, last paragraph. I think it's relevant, Lordship. Recording, Lordship, I think. Lordship. Page 81, Lordship, paragraph 10.
Which part are you telling me?
Page 81, Lordship, paragraph 10 of the order, Lordship.
To reinstate or to
Yes, Lordship.
post you somewhere?
Yes, this paragraph 10, Lordship. That for the reason above, Asman Authorities are now directed to reinstate.
What did I say? I said the order of suspension was interfered with.
Lordship.
And it was left to the wisdom of the
Yes.
departmental authorities whether to proceed with the departmental proceeding.
I limited understanding, Lordship.
We don't need quoting the order all the time.
Lordship.
Huh?
Obliged, Lordship.
It's a part of the record.
Lordship.
Anywhere you go with this order, you'll give a certified copy, it's done. By the order dated 11/10/2023, the Government of Assam Department of School Education had cancelled the promotion order of the petitioner from the post of headmaster of the Janata High School, Jorhat, and had directed the Director of Secondary Education, Assam, to go for initiate a fresh selection process as per existing rules. When the the petitioner approached this court by filing WPC 6466 of 2023, and on 10/11/2023, this court directed that the respondents were jointly and severally restrained from processing or finalizing any selection process for the post of headmaster of Janata High School, Tiok, Jorhat, during the pendency of the writ petition. Till the next returnable date, full stop. The copy of the said order was submitted to the Office of the Director of Secondary Education on 16/11/2023, full stop. The Department of School Education thereafter issued another order dated 15/2/2024, by which the Government of Assam had noted the submission of the Director of Secondary Education that the process of promotion to the post of headmaster of different provincialized schools had already been initiated, and had directed Sri Amal Kumar Borua, directed the petitioner to participate, had given the liberty to the petitioner to participate in the process, and his case would be considered if found eligible as per rule, full stop. In the meantime, the Director of Secondary Education by the order dated 8/11/2023 on the basis of the inquiry held against the petitioner pursuant to the office order dated 23/12/2020, comma, the order of promotion in respect of the petitioner to the post of regular headmaster of Janata High School under the Jorhat district, issued by the order dated 5/8/2017, stood cancelled. The petitioner was reinstated in service as assistant teacher science and was posted at National Telegraph High School, Girls High School under Jorhat district with immediate effect. The period of suspension was regularized only for pensionary benefits. The emolument already received by the petitioner during his suspension period were considered to be his entitlement. The concerned branch of the directors were required to initiate necessary process for filling up the post of headmaster of Janata High School on regular basis as per provision of existing service rules. The order dated 18/11/2023 was stated to have been issued in compliance of the Honorable High Court order dated 3/5/2023 passed in WPC 430 of 20. The petitioner thereafter approached this court by this presented petition, praying for setting aside of the order dated 20. The learned counsel, the next paragraph, the learned counsel for the petition submitted that although the order of 8/3/2021 is being challenged in the year 2023 is being 8/11/2023, 2021, no, 8/11/2023 in all places. Although the order of 8/11/2023 has been challenged in the present petition, which was filed on 15th of July 2024, the delay in approaching this court was because the petitioner had been served a copy of the order dated 8/11/2023 only on when?
9/7/24, Lordship.
9/7/24,
Lordship.
2024, full stop. The learned counsel for the petitioner has submitted that without prejudice to the challenge that the petitioner may have with regard to the allegations, correctness of the allegations leveled against him, the petitioner suffered grossly when this inquiring authority appointed by the disciplinary authority had violated all norms of natural justice, had violated all principles of natural justice and administrative fair play. Full stop. The learned counsel for the petitioner has submitted that the petitioner was not given any opportunity to cross-examine any of the witnesses who made statements, who may have made statements before the inquiry officer, the presenting officer, even when he was available in the inquiry proceedings when the petitioner was present, had not participated in the inquiry proceedings in a manner in which a presenting officer is required to participate, and had been a mere spectator, allowing the inquiry officer to conduct his own proceedings at his own free will. The learned counsel for the petitioner has submitted that he was called for inquiry to call for the inquiry only on one date,
Lordship.
when he made his statement, on the very next date when he arrived at the, when did you can you
Lordship.
give us the date
Lordship,
of the
I'm-
proceeding? Harry, finish it. Record.
In the inquiry report, it is also mentioned, Lordship.
Where is the inquiry report?
106, Lordship. Affidavit in opposition.
A
Lordship.
brown file to do.
And 24/9/2021.
Huh?
Page 106, Lordship. Affidavit, Lordship.
Where is it? Dates of hearing is where?
Lordship, in the second line, Lordship, Lordship, in pursuance of the office order, it is so. A hearing was held on 24/9.
The learned counsel for the petitioner has submitted that the hearing, the matter was held only on 24/9/2021, and immediately thereafter, the inquiry report had been submitted, full stop. It would be apparent if this court, no, in the event this court peruses the records of the inquiry, comma, it would be apparent that the inquiry proceedings had been initiated and had been taken up and concluded on the very same day without affording any scope of defense to the petitioner hearing. Change order to decall.
Another point, Lordship, I want to, Lordship, the here in this Lordship inquiry report, Lordship will find the witness Dalul Dulal Chandra Bora. He appearing on behalf of IS Lordship, and IS was the witness, listed witness, but this Dulal Chandra Bora was not witness.
The learned counsel for the petitioner has submitted that as per the memorandum of charge and the list of witnesses annexed thereto, and as per the notice received by the petitioner requiring him to appear before the inquiry body, the inspector of schools, JDC, Jorhat, was mentioned as a witness in the proceedings. However, during the inquiry proceedings held on 24/9/2021, the inspector of schools did not appear before the inquiry officer. Instead, one senior assistant appeared on behalf of the witness, namely Inspector of School Jorhat, full stop. The learned counsel for the petitioner has submitted that elaborate arguments regarding the merit of the allegations, etc., are not made in the, I have not been addressed since the disciplinary, since a departmental inquiry and its outcome is required to be assessed with regard to the procedure in which it had been conducted and the violation of a, and with regard to the violation of the fair opportunity of defense being afforded a delinquent official is concerned, full stop. The learned counsel for the petitioner has submitted that it would be apparent from the inquiry report annexed as Annexure G to the affidavit in opposition filed by the respondent parties themselves that the inquiry was held only on a particular date where 3 prosecution witnesses had been examined and
I was, Lordship, even not informed about the right to take assistance of government servant. And Lordship, most interesting, Lordship, the inquiry report was never served upon me.
this is just for a musing. When you can kill a bird with one stone. Why throw 100 stones?
Lordship.
Huh?
Lordship. I just pointed, Lord.
Huh?
I just
Now we'll
point-
take it into account. You want us to take it into account, we'll take it into account, but at your peril.
Lordship.
It'll
Not
be to your peril. Not now, later on. It will be to your peril.
Lordship.
The what did I say that last sentence to our copy? And the inquiry report itself does not reveal that the defense put up by the petitioner when his statement was recorded was even taken into account by the inquiry officer. The learned counsel for the petitioner has submitted that. What did you, what was the first point? That the petitioner had not been informed about his right to engage a defense counsel. Full stop. Another limb of argument of the learned counsel for the petitioner is that the petitioner had never been served a copy of the inquiry report. And therefore, he never had the opportunity to rebut the findings before the disciplinary authority could have taken a decision to his detriment. Any other submission?
Lordship, just Lordship, okay, Lordship.
The learned counsel for the petitioner is therefore agreed that the inquiry proceedings require the interference of this court, the extent of being set at naught. Once he further submits that once the inquiry proceedings are found to be not sustainable in law, any further penalty orders imposed upon him would also require to be set aside and quashed. The learned counsel for the petitioner has said that it is evident from the records, it will be evident from the order passed by the disciplinary authority that till the time the petitioner had been removed from his post of headmaster by withdrawing the promotion order, he had been holding the aforesaid post. Stop. No.
No, Lordship.
Tell us.
When reinstated, Lordship, I was registered to another college, Lordship, school, Lordship. Thereafter, Lordship.
You were suspended.
Lordship.
There was an in charge.
In charge. In charge is still there, Lordship.
It is not a regular headmaster who is holding the post.
No, Lordship. Now in charge is there, Lordship.
Who is the in charge?
One Kollan.
Tell us, that order had required
because Lordship,
that order had required a fresh selection process to be taken up.
Lordship.
What happened? They did not do it.
Did not do because there is interim order in this case, Lordship. That is second matter, Lordship. That
the learned counsel for the petitioner has submitted that in WPC number so and so preferred by the petitioner, this court had already restrained the respondent authorities from initiating any selection process, from proceeding with any selection process with regard to the post of headmaster of the Janata High School. Full stop. He submits that the said post as of today is being held by an in charge, and in case this court, and in the event this court sets aside the order dated 8/11/2023, the petitioner would be entitled to be reinstated in his post of headmaster of the Janata High School by replacing the in charge headmaster as of today. The learned counsel for the petitioner has further submitted that his removal from the post of headmaster being done pursuant to an illegal inquiry, the petitioner may also be held to be entitled to the benefits which might have accrued to him in the interregnum from the date on which he had been removed from the post of headmaster of the school till the date he is reinstated as the headmaster of the Janata High School. The respondents have filed an affidavit in opposition attested by the Director of Secondary Education. Full stop. Learned, no, Mr. P.P. Dr. Learned, Standing Council, Department of School Education has referred to the aforesaid affidavit in opposition and submitted that the petitioner, no, that it was apparent from the records available that the petitioner had refrained from giving detailed particulars about the source of his appointment, date of actual joining, and other information as to how he was placed under suspension pending trial of departmental proceeding. The learned counsel for the appearing for the Department of School Education has submitted on the basis of the affidavit that the petitioner was allowed to take classes as science teacher in the Janata High School, Jorhat, prior to the provincialization of the school. And the actual date of joining of the petitioner in the school, as per the records maintained in the department, was 5/2/1991 and not 10/10/1990. The learned counsel for the respondents have submitted that the petitioner had never submitted any application for correction of his date of joining in the Janata High School. And when a correction was seen to be appearing on the service record, the Inspector of Schools, Jorhat, had inquired into the matter and submitted a report on 4/10/2017 to the effect that the petitioner had manipulated his date of joining in the official records, which he had submitted during the time of filling up the applications for the post of headmaster of the headmaster, full stop. The learned counsel for the respondents has further submitted that the post which the post of assistant teacher of the Janata High School, which was held by the petitioner prior to him being promoted, had been filled up, and therefore when the promotion order of the petitioner was withdrawn, he had to be posted to another school, namely the National Telegraph Girls High School in the same district, to maintain his continuity in service. The learned counsel has further submitted that records would reveal that the representations and appeals submitted by the petitioner had received due consideration of the appropriate authority and had been appropriately disposed of by passing speaking orders. The learned counsel for the respondents has submitted that the prayers made in the writ petition being completely untenable in law, the same do not require any consideration of this court at this stage and deserve to be dismissed. He has prayed that the writ petition be dismissed without granting relief to the petitioner. The learned departmental counsel has produced the records of the departmental proceeding held against the petitioner, which are available in file number capital G, capital B, dash EST oblique DSE oblique allegation oblique 10 oblique 2020, maintained with the GB dash EST oblique branch of the Office of the Director of Secondary Education. This court has heard the learned counsel appearing for the parties, contesting parties, perused the pleadings made available with the case record, and has also gone through the original records produced by the learned counsel appearing for the state respondent. Next, please. It is a settled position in law that while evaluating the grievances of a delinquent who assails a disciplinary proceeding, the writ court is required to take into consideration the process which was followed while coming to a conclusion, process which was followed by the disciplinary authority in coming to a conclusion in the matter. And it would not be upon the writ court to comment upon the veracity or otherwise of the allegations leveled in the writ petition. Of course, in case the very allegations seem to be unreasonable or impossible, the writ court would be required to comment on the character of the allegations. In the present case, it does not appear to this court that this court is required to evaluate the correctness or otherwise of the charges leveled against. Therefore, to evaluate the grievances raised by the petitioner, this court has decided to look into the original records to find out if the allegations leveled by the petitioner regarding the lack of opportunity to defend himself during the inquiry proceedings were enough in law to vitiate the inquiry proceedings, and as a consequential relief, whether the petitioner would be entitled to be reinstated in his original post of headmaster. The show cause notice, along with the attachments, namely the statement of allegations, the list of witnesses, and the list of documents, are the same as is found in the records of the writ petition. There is a letter available on record that the period of suspension of the petitioner had been extended by an order dated 28/1/2021. By an order dated 8/2/2021, the Additional Director of Secondary Education had informed the petitioner that the list of documents had already been provided to the petitioner and that he was allowed to inspect the list of documents for preparation of reply on 23/12/2020 in the office chamber of the Additional Director during office hours. Full stop. It is not the case of the petitioner that he was refused an inspection. He, however, the grievance raised is that he was not allowed to, and he was not supplied with copies of the documents. Full stop. This court is of the considered opinion that when the petitioner had the opportunity of inspecting the documents, he could have taken notes as required during the inspection period, and in the letter dated 23/3/2021, the petitioner has expressed gratitude for being allowed to inspect the documents. Full stop. We do not find a prayer that he had requested the list of the copies of the documents be supplied to him prior to his filing a reply. The period of suspension of the petitioner was thereafter extended on 13/4/2021. No grievance has been expressed by the petitioner in this regard. Full stop. The reply to the show cause notice filed by the petitioner on 12/4/2021 was received by the Office of the Disciplinary Authority Director, Secondary Education, Assam on 12/4/2021 itself, the records produced by the Learned Standing Council reveal that the Joint Director of Secondary Education and a superintendent of the GB-EST branch office of the DAC were appointed as enquiry officer and presenting officer respectively to inquire into the allegations made against the petitioner by the Director of Secondary Education through an order dated 28th of June 2021. And take your seat. By the order dated 28th of June 2021, the Joint Director of Secondary Education, no, cut up. That was a draft. 20th June to Kati Dibu. 1st of July by an order dated 1st of July 2002. They were appointed, and so were appointed as the enquiry officer and presenting officer respectively. By an order dated 18th of September 2021, the enquiry officer, that is the Joint Director of Secondary Education, had required the Inspector of Schools JDC Jorhat, the petitioner, the President of the SMDC of the Janata High School, and the Assistant Teacher of the Janata High School to appear before the enquiry officer on 24/9/2021 at 11:30 AM in connection with the existing DP against the petition. They were required to attend with all original supporting documents, paper, including service book in connection with the selection of regular headmaster of Janata High School, Jorhat District, positively without. The allegation against you was that when filing your application, you had manipulated the records, is it not?
Yes.
So what was stated by Mr. Dotto in the morning half, that the inquiry should not have extended to find out whether it was a faulty application or not. I think that was an allegation against you and it could go to such an extent. And therefore, the inquiry officer can call for the records of the promotion process. I'm not clear. Counsel for the respondent had submitted that. Counsel for the respondent had submitted that the charge against you had nothing to do with the promotion. And therefore, the promotion should not have been inquired into by the inquiry officer.
Yes.
If I remember correctly, the charge sheet said you manipulated records while applying for the post of headmaster. Therefore, it was linked up. So I don't think his submission is correct on that line. The records could be called for.
Allegation is that at the time of
Submitting the application.
Yes.
So that record will be necessary before the inquiry officer. Is it not?
Yes.
Okay, we'll not comment on that. That will be for them to find out. The departmental records further reveal that the statement of the, who is this one? Where is the first statement recorded? That that Mahendra Nath Dotto, who was the witness number 4 during the inquiry proceeding, had given his statement on 24/9/2021. And who else? President of the SMDC, did he come?
I don't think so, because in the
Where is the inquiry report? See the inquiry report, who had come?
Lordship. 106. Amal Kumar Borua, headmaster.
Huh?
One Amal Kumar Borua, headmaster.
You are
Lordship.
Amol Kumar Borua,
Yes.
and
Then
three names are there
Mohendranath Dotto
that we have recorded. And
Dulal Chandra Bora.
where is his statement? Did he make any statement?
Lordship,
This
statement
Dulal
is
fellow?
not me, Lordship.
Huh?
Regarding deposition is not with me, Lordship records.
No, I'm just asking.
Lordship.
The record also reveals that the petitioner had given his statement on the same day before the inquiry officer. The attendance sheet annexed to the inquiry report, which is available in the departmental record, shows that the inquiry officer, comma, the petitioner, Mohendra Dotto, and the senior assistant of the inspector of schools on behalf of the inspector of schools was present during the inquiry proceedings. The inquiry report was submitted on
Date is not available, Lordship.
eh,
No date is available. No date is mentioned, Lordship.
in their affidavit. Have they stated anywhere? Please see.
Lordship.
In their affidavit, have they seen any stated anywhere? Ah, yes. You keep looking into it. We'll need that help. What was the date of the inquiry?
Inquiry date was, Lordship, 24
24
9
9
2021.
20.
Probably on that day itself it was prepared.
Although the inquiry report remains undated, comma, the office noting on 30/9/2021 reflects that the joint director of the DSE had suggested that the Inquiry report submitted in the matter of the disciplinary proceeding against the petitioner may be submitted to the Director of Secondary Education for necessary approval. It does. The file noting of 30/4/2022 reflects that the report so submit had been accepted. It is therefore apparent that after the inquiry report had been submitted, there is nothing in the official records to show that a copy of the said inquiry report had been forwarded to the petitioner to afford him an opportunity of replying to the inquiry report. Full stop. The learned counsel for the this court therefore finds force in the argument of the learned counsel for the petitioner that the petitioner never had the opportunity to rebut the findings of the inquiry officer. Full stop. The records, the official records do not reveal any prayer made by the by the petitioner during the inquiry proceedings that he wanted the assistance of a defense assistant.
The defense, actual government servants should be assisted, not counsel should not be. As per the rule, Lordship, government servant can assist me. No.
Did you pray for one? Did
Lordship,
you ask for one?
even Lordship, I was not informed that I have.
Why? You have so many information.
No, Lordship,
Ignorance of law, not an excuse, not before this court, please.
it is also their duty.
Services rules.
Lordship, their duty is also there to inform me about the right, Lordship, also.
Their duty are, they have so many duties. We have so many duties.
I found judgment also needed, Lordship.
In some services. Hey, show us where they have a duty.
Lordship.
Trust.
Rule 9, Lordship.
Rule 9 page.
Is in this.
Oh, we'll have
in my
different
book,
pages, huh?
Lordship.
Rule 9, yes.
Rule 9, Lordship. Sub-rule 6, Lordship. Sub-rule 6, Lordship. The inquiry authority shall, in the course of the inquiry, consider such documentary evidence and take such oral evidence as may be relevant and material in regard to the charges. The government servant shall be entitled to cross-examine witness, examine in support of the charges, and to give evidence in person and to adduce document and oral evidence in his defense. The person presenting the case in support of the charges shall be entitled to cross-examine the government servant and the witness examine in this effect. If the inquiring authority declines to examine any witness, the admit any documents, evidence in grounds of evidence, and such document is not relevant, it shall record its rating.
Tell us.
Lordship.
Tell us, defense witness.
Lordship, that be subpara 5, Lordship. Sorry, subpara 5, Lordship. The last line, Lordship. The government servant may present his case with the assistance of any government servant approved by the disciplinary authority.
Did you ask for it?
But may
Please
not,
approve so and so person.
but may not be.
Did you ask for it?
Lordship.
It is
But-
written in the rules.
But I have one judgment, Lordship, they have to
Which says that even if you don't ask, they have to give it to you.
inform that right I have, that right, Lordship. That they have to inform me that I have the right to
Judgment.
Lordship. I place the judgment, Lordship.
What is the judgment?
Lordship, I am giving.
You
I have
placed
that-
it here, this one. Jackson Master. The records do not reveal that he had made any prayer for such.
Lordship,
for appointment of such.
Jagadish Chandra
एक second.
Nath, Lordship.
Has not made any prayer for. Only get over defense assistant. Full defense.
Inquiry proceedings and
Inquiry proceedings for appointment or engagement of a defense assistant. First. Yes, tell us which one.
Lordship, Jagadish Chandra Nath, Lordship.
Where do we have that?
2019 4
Iraq
GLT.
Didi,
2019 4 GLT.
Tar Hussain, Satyendra Singh. Where?
Jagadish Chandra Nath, Lordship.
Gave it with this bundle?
Lordship, I think.
No.
I have.
You have another copy?
Lordship, I have.
Eh? Give us your copy, let us see.
Lordship.
Or give us your copy.
Yes. Paragraph 6 and 10, Lordship, 11. আৰু এটা কৰি আছে নেকি ইয়াত? হয় না? বিশ্বনাথ তেওঁ- ইয়াত
হৈ গৈছে। এই দিদি open shopping this. ঠিক নেকি? Some reported in 2019 4 GLT 1006 to impress upon this court that the absence of the petitioner, that the absence of information to the petitioner that he was entitled to avail the assistance of a defense assistant and the absence of the information to the petitioner that he had a right to cross-examine the departmental witness would lead to a procedural violation of Rule 9 of the 1964 rules. He has therefore submitted that. No. This court finds force in the aforesaid submission. The records of the departmental proceeding thereafter reveal that the inquiry report, etc., was thereafter forwarded to the secretary to the government of Assam Department of School Education, Dispur, Gauhati, on 3/2/2023 for approval. for cancellation of the order of promotion in respect of Sri Amal Kumar Borua to the post of headmaster of Janata High School, Jorhat, which was issued by the office order dated 5/8/2017. This court has noticed that the inquiry officer had called for the petitioner and the petitioner and the other witnesses named in the notice dated
Suppose lordship.
when we were called for
Lordship. That page 77, I think. Is 77.
18/9/2021 for all of them to appear before the inquiry officer on 24/9/2021. The records do not contain any noting to the effect, or for that matter, the inquiry report itself does not contain any reference that the petitioner had been given the opportunity of cross-examining the witnesses, that the documents which were placed before the inquiry officer were exhibited by the authorities who had allegedly who had issued them. No, were exhibited by the presenting officer, that the petitioner had been put to any advance notice that the superintendent of office of the inspector of school, Jorhat, would replace the actual witness called for, that is the inspector of schools, Jorhat.
Not superintendent, senior assistant.
Senior assistant, superintendent, senior assistant, or that the presenting officer nominated by the disciplinary authority had participated in inquiry proceedings in any manner whatsoever. In the absence of any reference in the inquiry report as to the participation of the presenting officer, this court is of the view that the inquiry officer had proceeded to lead the entire inquiry on behalf of the disciplinary authority. Full stop. He had thus, in view of this court, acted as a presenting officer and an inquiry officer at this. This court further notices that upon submission of the inquiry report before the authority, the disciplinary authority did not find it necessary to supply a copy of the inquiry report to the petitioner to have his comments or to give him an opportunity to rebut the findings arrived at by the disciplinary authority. The impugned order of recalling the order by which the petitioner stood promoted to the post of headmaster was also passed during the pendency of this litigation. in view of the above
Is to get their submit to
notice of the considered opinion that the disciplinary proceedings initiated against the Department of Inquiry conducted by the inquiry officer cannot stand the scrutiny of law. The order dated 8/11/2023, which had been passed by the Director of Secondary Education without affording an opportunity of the petitioner to have his reply on the inquiry report, also suffers serious effect which hits at the root of the issue. So this observation is root of the issue. The above view of the matter, the inquiry proceedings initiated conducted against the petitioner by the inquiry officer stand vitiated and are therefore set aside and quashed. Consequential orders revoking promotion granted to the petitioner are also set aside and quashed. The petitioner shall be entitled now to be reinstated in his post of headmaster in the Janata High School, so and so, which, as per statements made at the bar, is now being held by an in charge. The matter of record that the selection process had already been kept in abeyance by this court in WPC number so and so. Did not
646623. 2023. 6466 2023. Order dated 10/11/23.
the respondent authorities would be at liberty to continue with the inquiry proceedings against the petitioner from the stage of appointing an inquiry officer since it appears that the disciplinary authority involved in the matter, inquiry officer who was appointed was appointed to participate in the inquiry had really failed in their duty to adhere with the principles of natural justice, this court deems it fit that in case that the matter shall now be placed before the secretary of the Department of School Education, who shall take a decision as to the requirement of continuing the disciplinary proceeding initiated by the memorandum of charge dated so and so. And
23/12/20.
who shall appoint the inquiry officer and presenting officer if such a decision to continue the proceeding is arrived at. The proceed the commissioner, the Secretary of the Government of Assam, Department of School Education shall also nominate another director, another officer of rank equivalent to the Director of Secondary Education as the disciplinary authority in this particular case in the unique facts and Secretary of the Government of Assam shall ensure that no person who was involved in the earlier round of inquiry, even except the witnesses, shall participate in the inquiry proceedings if at all held against the petitioner. Petition is out to the extent indicated above. Anything else to be done? We'll have a relook in the chamber.
I don't know why I have prior to all other consequential benefits.
On his reinstatement, the petitioner should be entitled to incidental benefits which may arise.
Deeply obliged, sir.
Reinstatement inside. Whatever else is required to be done, we'll make corrections in the
Lordship.
chamber and then you'll have
And I
the
have
order.
also submitted the judgments and I have mentioned the paragraph also. If Lordship required,
Judgment kita boleh diselocate lagi kita.
Lordship can relance if you Lordship feel required, Lordship.
The records produced by Mr. P.P. Dotto be returned forthwith, or so that the same may be sent back to the department concerned.
And Lordship,
Kuntu. I have not finished the order. I have done 435 kana I have done it.
the second petition will also be disposed of. Lordship.
In view of the orders passed
Lordship.
in the present writ petition, and no further orders are called for in the WPC number so and so, as the issues raised in that WPC
Covered.
number so and so are be covered by the
Lordship.